Introductions by members. Madam Clerk.
Introduction of bills. Orders of the day.
Government House Leader.
Thank you, Honourable Chair. I call continued second reading debate Bill 5.
Member for Vancouver-Langara.
Thank you, Mr. Speaker. Just to continue on my remarks, just following the lunch break there, I was speaking just before the break that under Section 55, Sub 3 of Bill 5, that while the Lieutenant Governor appoints the Fairness Officer, it is the ICBC Board that may, subject to the approval of the Minister, set the terms and conditions of the Fairness Officer's appointment, including remuneration. So this is the challenge, Mr. Speaker, is that even though the Lieutenant Governor will select the individual to serve as the Fairness Officer, it is ICBC itself that will be determining and setting the terms and conditions of that Fairness Officer's appointment. As I mentioned before the break, that would mean, of course, that in terms of the appointment itself, the manner in which that individual is reviewed in terms of his or her performance, that it's all up to the board of ICBC to deal with that. And that, of course, the Fairness Officer will have the ability to retain staff to assist that officer in his or her role, but pursuant to Sections 55 Sub 4 and 5 of Bill 5, it is the ICBC Board that will approve the budget. So, Mr. Speaker, this so-called independent fairness officer will have the terms of their employment, their salary, and their budget decided by the very organization that they're supposed to be overseeing. That is not independent. That is being totally beholden to the corporate structure, ICBC, that you're supposed to be overseeing. The Attorney General has also said that the Fairness Office has the power to make recommendations to ICBC to ensure fairness. That is what is set out, as I mentioned at the outset of my remarks today, in Section 56. And so you would expect, though, that although the duties and the powers of the Fairness Officer as set out in Section 56 on the surface sound reasonable or beneficial to measure fairness, and that you would expect that this government would then provide the level of authority to this Fairness Officer to ensure that injured and vulnerable British Columbians are being protected in how ICBC implements this new no-fault regime. But if you turn to Section 56, it does say in Sub 1 that the Fairness Officer may investigate a decision or recommendation made, act done or omitted, or a procedure used. The challenge, Mr. Speaker, is this. It's the restriction set out on the jurisdiction of the Fairness Officer in 57 Sub 1 of the bill. And that, Mr. Speaker, clearly states that the Fairness Officer may not comment or make recommendations respecting an amount payable by the corporation or the extent as determined by the corporation that a person is responsible for an accident. Mr. Speaker, as I spent some time before the break going through the new regulations that were also issued to come into effect on May 1st, issued last Friday by order in council, all speak to the payment. How much is an injured British Columbian entitled to for their injury? And this is the challenge, Mr. Speaker, because the real purpose for ICBC under the no-fault scheme is to pay to injured British Columbians the health and disability benefits, as well as other compensation. That is what British Columbians expect ICBC to do here. And the fairness officer should be in a position to ensure that this is done fairly. And yet, Mr. Speaker, this bill, under Section 57, prohibits the fairness officer from even making a recommendation about what ICBC is paying or not paying an injured British Columbian. Also, the fairness officer not even make a recommendation about when an ICBC adjuster holds an injured British Columbian at fault for an accident. We know in British Columbians who deal with ICBC, it comes down to these important determinations. The fault determination for responsibility, as well as the benefits and compensation. These are the fundamental points that British Columbians need from their insurer. And as I mentioned at the outset, with the challenge to the CRT and their jurisdiction as being seen unconstitutional, that was another area where British Columbians were expected to seek relief, to seek fairness, to resolve their disputes. Without that, and with a fairness officer that is very highly restricted in their jurisdiction, what are British Columbians left with? This is after, of course, under the previous bills that we debated at length last summer, this government taking away any ability, other than in certain very high-level threshold circumstances, of injured British Columbians coming forward to seek legal relief. So, Mr. Speaker, when you look at this Bill 5, we have a situation where it doesn't meet what the Attorney General had indicated he would provide, the peace of mind. Peace of mind isn't provided just by words on the page. A fairness officer that doesn't actually have real authority to get into the matters that most affect injured British Columbians. We know that the challenge with ICBC has been that they lack the trust and the confidence of British Columbians. This is the challenge that this government has acknowledged. That with the track record of delays or denying benefits, now there are no consequences to their decisions. Without a fairness officer that can actually look into, comment even, on the amount payable by the corporation or to the extent that a person is responsible for an accident, without those important determinations, if that's taken off the table, British Columbians are left with very little. So, Mr. Speaker, it's been well over a year since the the Attorney General made his first speech about the Fairness Officer and what it would look like. This is now just 7 weeks before ICBC has full control over the lives of injured British Columbians. And with this bill, Bill 5, we see now just exactly what this Fairness Officer is. It's a toothless, powerless entity that is controlled by ICBC every step of the way. The minister in charge of ICBC has the important responsibility of checking and balancing the incredible power ICBC wields over British Columbians who are forced to buy their auto insurance from this monopoly under this no-fault regime. And this bill is another example of their total failure of that responsibility. The NDP have given full power and control to ICBC, and British Columbians should be very, very concerned.
Thank you, member. Recognizing the member for Langley.
Thank you, Mr. Speaker. I guess once all the chairs at the feast are pulled away, there's nothing to do but stand around and point fingers. This bill, this act, is about fairness. This is about restoring public trust in ICBC, public trust that was decimated by the last government. And before I begin, I'd like to just touch on a few comments that a couple of our colleagues from the opposition benches have made over the course of this debate. And I'm not going to get too much into the strange fixation with the Attorney General that the member for Vancouver-Langara has, but I will say that what we've just heard is an outdated view of the legal system that rights can only be protected in courts. Those comments are largely ignorant of the rise of the modern administrative state, of all of the protections that have been put in place in the entire province of administrative law. Now, I'll agree with the member for Langara on one point. He said in his speech that court challenges ain't cheap. And boy, is he sure right about that. The cost pressure from excessive litigation combined with liberal mismanagement of the Crown Corporation are what have led us into the mess that we are cleaning up right now through enhanced care and through acts like Bill 5. So, I want to just say a word, about our good friend, the Attorney General. And I just want to say what an honor it's been to know and to get to know the Attorney General, especially in this role, but previously as well. And how refreshing it is to have an Attorney General that's focused on people and not narrow interest groups. And you've seen that through his advocacy on ICBC and the policy implementation and formulation on the ICBC file. And really, the Attorney General is an example to the entire legal profession. He's a paragon of competence and ethical correctness that I think that we all ought to aspire to. And I would hope that, other lawyers in this House would also take that example. Now, I want to turn now to the bill, Mr. Speaker. And in doing so, I just want to go back to a comment made by the member for Prince George Mackenzie. Namely, if it ain't broke, don't fix it. Well, guess what, Mr. Speaker? The system's broken. Public trust in the system has been broken. The BC Liberals destroyed public trust in ICBC in their last term in government. They approached ICBC like a vulture capital fund approaches a new acquisition. And they ran it like Mitt Romney ran Bain Capital, putting their hands into the piggy bank, trying to strip away as much value as they could until there was nothing but a carcass left. They even tried to sell the building to a lobbyist. And what that meant was a $1.2 billion were stolen from ICBC, were stolen from ratepayers and led to increased rates. And that led to intense cost pressures as well and put the entire system at risk. So this is about good public policy. This is about good process. And this is ultimately about fairness, and fairness for folks who are going through the system and fairness for ratepayers as well, Mr. Speaker. We even had to pass a law, and this is just, it's almost satire, but we had to pass a law banning the government from stealing money from ICBC, from treating it like a piggy bank, from taking excess optional capital out of the corporation. And passing that law means that the next government won't be able to do that should the public ever forgive the BC Liberal Party for what they did to this province. I'm not sure they will. But, that has meant that the corporation is on good financial footing, right? That they're able to reinvest that excess optional capital in rebates for ratepayers, putting money back into the pockets of folks in communities like mine in Langley. Now, on the member for Prince George Mackenzie's comment that if it ain't broke, don't fix it, I would urge him to take the advice that the members from the opposition were giving earlier in this chamber today in question period, and that's to look in the mirror. You broke it, we're fixing it. Now, at the end of the day, Mr. Speaker, what this ultimately comes down to is delegated authority. Now, we've heard from the member for Prince George Mackenzie that he doesn't think this is necessary because there's already a fairness commissioner in place that's accountable to ICBC and is functionally a creature of ICBC. Well, part of restoring public trust means that we need to look at the question of delegated authority and whether or not that fairness commissioner can wear two hats, which is to be a fairness commissioner that looks into the processes and procedures used by the Crown while also being a creature of the Crown. So what this bill does is it creates an independent fairness officer that whose authority is delegated by the legislature, by the act. And, that means that folks can have reasonably strong certainty that the fairness officer is acting in an independent manner. Now, the job and the role of the fairness officer, and I'm a little confused by the member for Vancouver-Langara's speech, which seemed to at one point suggest that the fairness officer should be some kind of court of appeal for damages, and legal determinations of liability, which, given his commentary on the on what he views as the tragedy of removing things from the hands of courts necessarily, that was a little confusing, to say the least. But the role of the fairness commissioner is really about, what we call natural justice or procedural fairness. And turning to the legislation, and some of the legislation our friend from Vancouver-Langara turned to, Bill 5, Section 56, it's very clear. The fairness officer may investigate a decision or recommendation made, an act done or omitted, or a procedure used by the corporation during or with respect to a corporation process that aggrieves or may aggrieve a person. I mean, that is the province of administrative law right there, and that is making sure that folks have the procedural protections and fairness and a guarantee of that, and someone with reasonable independence that they can turn to ascertain these questions. So that's incredibly important. And additionally, that officer is able to make recommendations to resolve fairness complaints, to deal with systemic issues about fairness. And those recommendations aren't just going to die in some black box in a corporate boardroom. They have to be reported out to the minister. So ultimately, this is about creating accountable processes to make sure that there's proper oversight, and not to create a black box of missing cabinet documents and accounting tricks, so that no one knows what's really going on. Well, ICBC is raw blind. So the Bill 5 is a good act, Mr. Speaker. It ensures process focused. It's process focused and ensures natural and procedural fairness. And quite frankly, ICBC shouldn't be a star chamber. And this addresses that by creating transparency that will ultimately go to helping restore the public trust in ICBC, which I realize, Mr. Speaker, is a difficult job because of what the last government did to that corporation. And furthermore, the independence here is clear, and it's very structural. Right, the fairness officer will be appointed by the lieutenant governor through order in council and no longer be a creation of the corporation itself. The costs will be borne by ICBC, and ultimately the minister, and through the minister's accountability to this house, there will be strong public accountability, and to make sure that there is independence in that sense. ICBC's board is going to be required to report to the minister responsible on all recommendations provided to it by the fairness officer. And, like I said before, that ensures this doesn't just get filed away in some banker's box somewhere, and dies in a storage closet. So this is, Mr. Speaker, part of a broader system reform. This is moving from an adversarial litigation-focused system that puts the needs of lawyers and others first, to a system of enhanced care that puts the needs of individuals, of the victims of accidents, at the forefront, and not special interest groups, not lawyers working on contingency. This is about people at the end of the day. And it's also going to lead to a 20% rate rebate, or a rate decrease. So, this is very clear. This is a good act. And I hope that, the members of this House and in committee will take a very clear look at it line by line and see what a good act it is. And that, that it's not misrepresented. Because we've heard a lot of very, confusing misrepresentations and criticisms here that, oh, well, look, this really does nothing. Because all you're doing is you're appointing a fairness officer by statute, as opposed to having a fairness commissioner appointed by the board. And, oh, hey, look, this is actually really disastrous because they don't have all these powers and it's going to destroy the whole system. Well, which is it? It's very clear that this is a good act that's going to result in ensuring the procedural fairness and natural justice for those who have issues with ICBC's procedures and processes. And that is where it begins and where it should end. It shouldn't be given legal jurisdiction to make legal determinations about damages and liability. That's not its purpose. And it rightfully isn't its purpose. There are avenues to make those determinations. And that's appropriate and as it should be. So thank you very much, Mr. Speaker, and I strongly support this act.
Thank you, member. Recognizing the member for Kelowna Mission.
Thank you very much, Mr. Speaker.
Just 1 second. Yeah. Member for Vancouver-Langara.
Thank you, Mr. Speaker. Just rising on a point of personal privilege, just listening to the comments from my colleague across the way and the member from Langley, I would ask you to consider and ask the member to withdraw his comments when they allege criminal conduct by the previous government. Uses of the word stealing are clearly not parliamentary language, Mr. Speaker.
Thank you, member. I will take it under advisement. Member for Kelowna Mission.
Thank you very much. I'll remove my first sentence because my colleague from Vancouver-Langara has already taken exception there. I want to thank my colleagues, both the MLA from Prince George Mackenzie as well as from Vancouver-Langara, for their comments. And I'll try not to duplicate too much of it. I do want to say that on a couple points outside of what has just been mentioned from our colleague and member from Langley, is that the revenues that he alleged, they went into generalized revenue, and generalized revenue comes from taxpayers. So, the member from Langley spoke about rebates, but I just want to remind the member that rates have skyrocketed in the last 2 years under their government, in some cases by 40%, 50%, 60%, in some cases 40% year over year. So to give back a 0.004% rebate after having taken an additional 40, 50, 60% from taxpayers and from ratepayers isn't really a rebate at all. So I'm going to also talk about just really what I see as the major issues of this bill. I'm my goal as an MLA is really to make life easier for British Columbians. I want to increase their health and welfare, and I also want to decrease cost and complexity. And today we're examining this bill that really has the government changing ICBC, and it doesn't seem to fit any of these criteria that I just mentioned. In this instance, it really looks at, and I'm going to take exception with the changes to the ICBC Fairness Officer. The proposed position is just not really new. It's not adding anything. And the changes then seem very unnecessary. My largest concern is that the independent governance right now, responsible to a board, is then going to be taken out of that context and now responsible to government. So, we're arguing over independence and at which place or space that this particular position is independent. I want to say that really we're arguing about whose dependence this position is on. Is it to ICBC or is it to government? Well, government doesn't have a great record over the last couple of years or months or even days of governing in these particular instances. So I'm concerned that we're taking this commissioner and putting it into an officer, but really giving it very similar duties. And at present, this independence, as I see it, right now, the ICBC Fairness Commissioner is appointed by and is responsible and reports directly to the ICBC Board of Directors. Well, Board of Directors have very strict adherence to certain governance aspects and due diligence, and can be held liable if that context is if their due diligence is not done. But government doesn't necessarily have that same. And Bill 5 is going to change who this fairness officer actually reports to, because it will be independent of ICBC's board, but now dependent and completely dependent on government. So this change, the officer is going to rely on a legal framework rather than simply having a terms of reference. And like the existing commissioner, the officer will have the scope to investigate and make recommendations to resolve customer complaints about the policy and process ICBC used to make a decision. So it really doesn't seem that there's a lot of changes or differences. And in terms of it being better in the case of the ratepayer, I just simply, I don't see that. It should be noted that this position expressly prohibits and is prohibited from investigating matters related to accident claims and paid amounts. So then why would they require independence from a board? The addition of time and cost without a different outcome is nothing more than bureaucracy. So are we simply increasing bureaucracy? If we calculate the time that we are all taking to debate this bill while paying everyone here to do this, but not achieving a different outcome that meets the requirements for nothing more than a bureaucratic change. So again, Mr. Speaker, I'm looking forward to getting more into the details of this legislation and the proposal for a new ICBC Fairness Officer. But I feel like we already have a working process. And ultimately, we want the average ICBC ratepayers, the people who drive in this province and may rely on their vehicle to travel to and from work, or perhaps someone driving an elderly parent to a medical appointment, we want them to be served by this new position. We want to make sure that this new position provides them with an effective and valuable service that is for their benefit, not just an increase in red tape, not a decrease in accountability, and not to do nothing more than bureaucratic changes. So I have yet to understand, and nothing that I've heard so far in this debate has convinced me that this new position actually protects the legal rights of British Columbians. I don't see how it's going to reduce costs. And if anything, I see how it adds complexity and costs and takes away independence from a board while putting it into the hands of government, which is really just bureaucracy, and I think will result in higher costs. So I'm going to leave my comments there at this point and look forward to taking more of a look when we get further into debate.
Thank you, member. Recognize the member for Courtney Comox.
Thank you, Honorable Speaker. It is my privilege to speak today to Bill 5, the Insurance Corporation Amendment Act 2021. It is a bill to create the position of a fairness officer to be appointed by the Lieutenant Governor, not ICBC, and to set out their powers and duties in relation to fairness complaints. This fairness officer would be independent of ICBC, not someone who works for ICBC. It's someone who's an objective third party who ICBC customers can turn to review the fairness of the process that led to the decision in their case. It's important to note that the fairness officer is remunerated out of the ICBC budget. That's important. And that the terms and conditions of the position are subject to the minister's approval. Also, the fairness officer's budgeting process is prescribed by regulation. That fairness officer is appointed for 3-year terms. Some people may not get excited about oversight, excuse me, over process, but it is the framework that, if built properly, ensures transparency and accountability, something that's so important to our public. And that builds greater public confidence in the new way of doing business with ICBC, knowing that those principles are being honored. As of May 1st, ICBC's enhanced care coverage will come into effect. It'll provide access to significantly improved care and recovery benefits, regardless of who is responsible for the crash. This is a significant shift in ICBC's culture to one that's focused on helping injured people get better. It's fair to say that we can be optimistic that there will be less demand for dispute resolution overall. But it is a shift, and it deserves an independent eye to make sure of the fairness of ICBC's processes, an eye that is entrenched in legislation rather than policy. Earlier this morning, listening to the member from Kamloops South Thompson speak of competence, I would remind this House of the ICBC dumpster fire our government inherited from that former minister and the now opposition. They raided the ICBC coffers to the tune of $1.2 billion, which caused drivers' premiums to increase. It's hard to forget that number, $1.2 billion. Let's talk about incompetence by the former BC Liberal government. The opposition also concealed the financial issues ICBC faced, using accounting tricks to hide hundreds of millions of dollars of losses. As the minister responsible at the time, the member from Kamloops South Thompson tried to give away ICBC's building worth $3 million and signed off on $1 million in bonuses to ICBC executives while the corporation was circling the drain. That all adds up to an egregious incompetence. The opposition opposes our plan for enhanced care. We've heard them in question period, and their comments raised that in this House and the record suggest that the people of BC would be poorly served by their path. Following their previous path would result in double-digit increases. And there's a lot of comparisons made to some of the other provinces saying that they have better systems. Well, some Alberta drivers recently saw their rates increase by nearly 30%, and the rate shock in Ontario brought by private insurers is through the roof. I heard that one Rampton family received a 62.5% hike. That's not affordable. With the changes instituted so far by our government, ICBC customers are getting rebates. And with our new enhanced care model, which starts May 1st, the people of BC will see a more affordable system that will be positively focused on care and recovery. The independent fairness officer is independent of ICBC, ensuring customers will have a place to turn to if they are concerned about the fairness of the process leading to a decision, an action, or a practice of ICBC. To be clear, it's issues like, was all the evidence considered? Did ICBC hear the customer's points that they raised? Did the customer get an explanation from ICB as to why the customer's points were not enough? Establishing a more independent fairness officer builds on our government's goal to make sure people get the care they need when they need it and for as long as they need it. Independently overseeing checks and safeguards for procedural fairness are an integral part of making sure our public insurer serves us well through what is often the darkest of times when we suffer injury in a motor vehicle accident. In conclusion, I want to express my wholehearted support for Bill 5 to create that independent fairness officer. Thank you, Mr. Speaker.
Thank you, member. Recognizing the member for Vancouver, Kensington.
Thank you very much, Mr. Speaker. I'm very pleased to be joining you from the traditional territories of the Musqueam, Squamish, and Tsleil-Waututh Nations. I'm pleased to rise and speak in favor of Bill 5 at second reading, the Insurance Corporation Act, with respect to the Fairness Officer, Mr. Speaker. And so as we're entering into these deliberations today on second reading on Bill 5 and talking about the significance of the Fairness Officer and how that fits into our transition to an enhanced care model in ICBC, just want to contextualize my remarks in the context of the shift that we've seen in ICBC, why our government has made these changes, and really understand the role that the Fairness Officer will play in terms of ensuring that British Columbians receive the quality the quality coverage of insurance and certainly the care that they deserve in the event of accident through motor vehicle accidents. So, Mr. Speaker, we know that our current the previous system was could be characterized as a litigation-based auto insurance system. And in my view, Mr. Speaker, it wasn't working for people. We knew rates were increasing, benefits were low, and it was really a system where we saw just a disproportionate amount going towards court costs and legal fees. Mr. Speaker, if someone was injured in a crash, their insurance should cover them and ensure they're supported so that they can get better. The previous system encouraged, the current system until we transition, encourages people to lawyer up and go through years of court proceedings, sometimes only receiving a fraction of their settlement once excessive legal fees are paid. And certainly not the situation I think that British Columbians expect, that if they find them or their loved ones or their family in the terrible situation of injury or death through motor vehicle accidents, they should be adequately supported. So, Mr. Speaker, it's with this, it's with the expectation that system, is unacceptable to British Columbians. On the one hand, facing skyrocketing rates. On the other hand, while ICBC lost hundreds of millions of dollars, we really saw that hemorrhaging out of ICBC. And that's why our government, Mr. Speaker, made the decision to transition to the new enhanced care coverage model. And this leads into the role that the Fairness Officer plays in a context to deliver that those benefits, to ensure that the model is implemented, and really to restore trust amongst British Columbians. And really that we've seen that trust eroded over a number of years due to the mismanagement of the previous government, Mr. Speaker. The enhanced care coverage model. Now, we've looked at auto insurance systems across the country, and the enhanced care coverage model comes from successful programs in place in Manitoba and Saskatchewan. And these two provinces have been able to consistently deliver, on the one hand, the lowest insurance rates in Canada, and on the other, with the highest levels of accident benefits. So often you would think that those were in contradiction to each other. But we know that people in those provinces, they've been enjoying low rates and high levels of coverage for years. And so maintaining a public system, we've taken components that have been in these systems and delivering the results that we want and that British Columbians deserve. Now, the enhanced care model, it comes out of, in terms of ensuring that British Columbians have low rates and also enhanced coverage in the event of accidents on the road. It comes out of, Mr. Speaker, the mishandling of ICBC. We know that during its time, the opposition raided $1.2 billion from the coffers of ICBC, which caused drivers' premiums to increase. And the role of Bill 5 and the fairness officer is being put in place to address really that erosion of trust that has happened in ICBC. In addition, the previous government, and it was the member currently for Kamloops South Thompson, even tried to give away a $3 million building that ICBC owned. When he was minister, he tried to give that away to lobbyists. He signed off on $1 million in bonuses to 6 executives in just 2 years, a practice that was stopped by our government, and really didn't show the putting people in British Columbians and their welfare at the center of ICBC. Really, the previous government had a record of not only benefiting their close friends and lobbyists, but on the one hand, increasing premium rates, and on the other hand, limited benefits. So, Mr. Speaker, that's the context in terms of moving to ICBC with the enhanced care model. We know that the old government ignored ICBC problems and allowed it to become a system that made lawyers rich while kept drivers paying ever higher premiums. And the changes that we're making to ICBC will save British Columbians money on their insurance and also deliver better support and take better care of British Columbians if they're injured in a crash. So, Mr. Speaker, how do we achieve that? On the one hand, to reduce rates, and it's taking out of the equation the role of lawyers and really having this forcing British Columbians to go to court to get the benefit and care they need. So we're removing expensive lawyers and legal costs from the system, which will save money on insurance and also allow for more funds and more resources to go towards providing better care. So anyone injured in a crash gets the care they need without having to hire a lawyer to get the benefits that they paid in for the insurance and that they deserve. Bill 5, Mr. Speaker, plays a key role in terms of this transition and to operationalize the enhanced care model. The ICBC Fairness Officer will come into place. We know that the ICBC enhanced care coverage comes in later this year, May 1st. And any British Columbian injured in a crash will have access to significantly improved care, improved recovery benefits. And this is regardless of who was responsible for the crash. Mr. Speaker, previously in our system, it was an impossible situation. You had individuals who were the victims of a crash and injured needing to sue also ICBC. So they were covered by ICBC, but they had to sue ICBC to sue the other driver who was also covered by ICBC and go to court. And so the situation was, the driver who was responsible had a lawyer, the victim of the accident had a lawyer, and they were both going to court. And so ICBC was in the position of defending against the person who was in the accident and also prosecuting and trying to get benefits out of the driver. So this wasn't a system that was working for people, Mr. Speaker, and the transition to the enhanced care coverage, removing the need for British Columbians to go to court to get the care that they required. That's a transformation of our system. And I think that British Columbians, it meets the head nod test when British Columbians expect that when they buy insurance, public insurance, it should insure them in the event of accident or injury while they're driving, and that it shouldn't put them in a position where they have to go to court. On the one hand to sue ICBC, and the other to defend against ICBC. Now, the process around what's in terms of the transition to this model, and also the need to restore public trust, because the previous government had eroded that trust by siphoning $1.2 billion out of the system, and by the increasing rates, and also such a system of litigation. This is the role, Mr. Speaker, of the Fairness Officer. The Fairness Officer is the purpose is to establish an independent fairness officer to ensure, and this lines up with the goal and reinforces the goal and plays the role to ensure that people get the care they need when they need it, and for as long as they need it. And Mr. Speaker, we need to ensure that there's procedural fairness towards this goal. It is, Bill 5 will move towards creating a more independent body to consider customer complaints about ICBC processes as part of, I referenced earlier, part of our broader effort to build public trust in the corporation as one dedicated to both affordable auto insurance coverage and caring for people who are injured in traffic crashes. So the role of the Fairness Officer is that to be an avenue in the event that either party disagrees with the decision that ICBC has reached. So ICBC, of course, undertakes every effort to ensure the process is fair in dealing with an individual. But certainly, Mr. Speaker, there may be occasions when policies and processes lead to unfair decision making. And so the role of the ICBC Fairness Officers is to ensure that ICBC customers, British Columbians, will have an objective third party to review the fairness of the process that led to the decision in their case. And this would be within the jurisdiction of the Fairness Officer to deliberate on those cases. If the officer determines that the decision was unfair, a recommendation is made. And that's an avenue that is available for British Columbians and customers of ICBC. I know questions have come up from the other side and asking why is it that Bill 5 is proposing to establish a fairness officer when we have an ICBC Fairness Commissioner. So I'd like to address that point and explain that. I think if members take a look at the jurisdiction, the role, and the scope of responsibility, that will answer that question. So the changes to the Insurance Corporation Act in Bill 5 are the intent is to further public trust in ICBC and to ensure that its processes have a more independent person reviewing fairness complaints. And so what's being proposed with Bill 5, with this legislation, is the Fairness Officer will be appointed by government rather than ICBC. So that's one critical distinction between the ICBC Fairness Officer and the Fairness Commissioner. The Fairness Commissioner is appointed by ICBC, plays that role, and the Fairness Officer, it will be appointed by government, so outside of ICBC, and to have the perspective of an objective third party. So that's one important distinction. As well, the reporting out requirements for the new Fairness Officer will enhance accountability to the government, ICBC, and the public. So that's another area, distinction and contrast, and distinguishing roles and differences between the Fairness Commissioner and the Fairness Officer. What are some other contrasts, or what are some other differences between the Fairness Officer and the Commissioner? The current Fairness Commissioner has been The current Fairness Commissioner has been successful in holding ICBC to account, but the Fairness Officer into law the mandate will be set out in the legislation, and the terms and conditions of the position is also subject to approval of the ministry. We know, Mr. Speaker, that the current Fairness Commissioner reports annually to the board on the matters that is being heard, and the Fairness Officer will be required to submit a report to the ICBC board, and the report will be posted on a publicly accessible website. And so that will be available, and there will be that transparency to the public as well. So there's the reporting, the reporting requirement, and that it's will be accessible to the public. We know that now we have the questions that have been raised with respect to, I think that lays out some of the contrast between the Fairness Commissioner and the Fairness Officer. We also have other avenues in place for British Columbians to bring concerns specifically to ICBC more broadly. We have as well the Civil Resolution Tribunal and the Ombudsperson. So we know that the enhanced care coverage is really proposed to be transformational to the culture of ICBC, that enables ICBC to focus solely on helping injured people get better, and to allow ICBC as an organization to focus on that and not to be split between having to mitigate between to defend itself against injured ICBC customers who are seeking benefits. So that requires it's a transformative change in culture, and where ICBC will be working collaboratively with an individual to support them navigate through the healthcare team with recovery and care in mind. So that will lead to a less of a demand for dispute resolution overall. We're really taking out that inherent contradiction in terms of that ICBC pretty much could be expected previously that you had to get into a fight to really you had to fight for the benefits that you were entitled to. So we want to ensure that ICBC as an organization focuses on providing that support and benefits to people to ensure that they are supported through their recovery, and that the role of the Fairness Officer will be, so the regulations will lay out the duties and functions, and the general responsibility for the Fairness Officer will to focus on ensuring that ICBC's policies and practices leading to a decision are fair, so that British Columbians can have that confidence, and that they also have an avenue to raise concerns if they disagree with a decision. Now, we mentioned the Ombudsperson. That as well, and British Columbians know that the Ombudsperson takes a wide range of concerns that British Columbians are not being able to resolve with government, and so any matter can be taken to the Ombudsperson for consideration, and the Ombudsperson will continue to be an avenue for British Columbians to resolve their concerns if they're not satisfied. And we've also introduced the Civil Resolution Tribunal, which is independent from ICBC. And so that's another area as well that's further to be laid out and articulated in terms of the role that will be played, and that laying out the jurisdiction as well. That's to be determined, Mr. Speaker. With respect to Bill 5 and questions around the findings of the officer, will the findings be binding, and what are the scope of powers that are different from the officer and the commissioner? Now, with Bill 5, the Fairness Officer's recommendations are non-binding. However, the ICBC board is required to report to the minister responsible for ICBC on the recommendations from the Fairness Officer, and to provide a summary the board's response to those recommendations. So that creates another level of oversight and engagement from the ICBC board and also going to the minister. And so it also provides an opportunity for the commissioner to also be brought into the conversation. And the difference is that the jurisdiction of the fairness officer will be in legislation. That's a significant difference rather than in ICBC policy that the commissioner is included under. So those are some of that's some of the scope, some of the differences, the distinction between the fairness officer and fairness commissioner within ICBC. And the main goal and objective is to ensure that procedural fairness is rigorously upheld, that public trust is restored within ICBC, and that processes are clearly in place for British Columbians to bring concerns forward if they do not agree with decisions made in ICBC. So it's proposed that the fairness officer's terms will be 3 years, renewable, and there'll be a period of transition as well in terms of working out the relationship between the fairness officer and fairness commissioner. We know as well that in terms of who will pay for the fairness office, that will also come under ICBC, including costs associated with operations and staffing. And we expect that this is this additional the additional responsibility of the fairness officer will add to really and support the culture of transparency and support the shift towards the enhanced care model and the organization ICBC being able to focus on providing care for those who are injured, and also that procedural fairness is laid out and that options are available. So, Mr. Speaker, there's been a lot. It's been a big overhaul in ICBC. It's focused on providing better care, providing enhanced care, bringing down costs for British Columbians, and that it removing lawyers and legal fees from the equation, and really removing such a conflict, such a conflict-ridden process. It's really the last thing that folks involved in accidents are needing to get care, need to be involved in. I know all of us, all MLAs in our offices right across British Columbia, have constituents who've come in and family members and friends who've unfortunately been involved in accidents, and often it can take years in terms of going through the process. It's very stressful. It's terrible to be in an accident or to have friends and family injured, and to be put into a legal situation where they have to go to court and they have to really fight it out in terms of getting benefits. They're often recovering from injuries, and it's a challenge to get adequate medical treatment. It's just a system that wasn't working for people, Mr. Speaker. And so with the enhanced care model coming in May 1st, and really focusing on providing the care to those who are injured in accidents, and ensuring that they are supported for their full recovery, bringing down costs of insurance for British Columbians, and really providing the confidence of British Columbians in the transformation of the system, and ensuring that there's procedural fairness, and that British Columbians know that not only the Fairness Commissioner, which is appointed from ICBC, but in addition, the Fairness Officer is also an avenue in terms of that is available to ensure that procedural fairness is carried out. So, Mr. Speaker, and just to conclude, in terms of the second reading for Bill 5. I'm in support of this bill. It's another important step towards restoring the trust in ICBC, supporting the bringing in the enhanced model of care in ICBC. And I'm confident that the role of the Fairness Commissioner will help to restore the trust that British Columbians have in ICBC that has been badly eroded under the previous government. So thank you very much for the opportunity, Mr. Speaker, to speak in favor of Bill 5 in second reading.
Thank you, member. Members, the member for Vancouver-Langara rose on a point of personal privilege to raise a point regarding parliamentary language. I would like to note that the proper mechanism to raise such a concern is to do so as a point of order. With respect to comments made by the member for Langley, I find that although the member was critical of the former government and the language chosen was intemperate, but in my view at the time and currently it does not require an unequivocal withdrawal, which is the only avenue open. I will also remind all members that when considering unparliamentary language, the chair takes into account the tone, the manner, and the intention. I will continue to listen closely to the debate, and I would advise all members, especially new ones, to look at their colleagues for how they handle such delicate issues and follow accordingly. Thank you. Leader of the third party.
Thank you, Honourable Speaker, and I appreciate your comments. I think it's always good for us to try to raise the dignity of this noble institution that we are so fortunate and privileged to be a part of. I'm delighted to be speaking today to Bill 5, the Insurance Corporation Amendment Act 2021. And this bill speaks about bringing in a fairness officer, which on the surface sure sounds like a very good thing. We all want fairness in our institutions and our government services and how the public is treated. So this bill identifies the role of the fairness officer and the relationship that that officer will have with ICBC, and also identifies that the officer can, quote, make recommendations to ICBC, but this officer will not be able to compel ICBC to take actions. The fairness officer will be appointed by cabinet, and the fairness officer will make public the type and number of issues that they hear, along with the recommendations to ICBC. Section 55 of the bill identifies how the officer will be appointed and the term of appointment, which is 3 years, and Section 56 outlines that the fairness officer may investigate decisions, acts, or procedures by ICBC. The officer may also make recommendations to ICBC to resolve fairness complaints or systemic problems with fairness and may provide advice to members of the public. There are a number of questions that we look forward to canvassing, and I'm sure hearing canvassed by the members of the official opposition during committee stage, including if the fairness officer, for example, cannot comment on amounts payable by ICBC, does this mean that any issue relating to benefits are out of scope of the officer? Also, would the officer be able to comment on services provided to claimants? It would be good to get clarification on this. Also, it would be interesting to know how this fairness officer can actually help individuals in a timely fashion if ICBC's responses only need to come a year later to the prior fiscal year. Other points that have been raised over the debate in the chamber this afternoon have been around how independent this fairness officer will be, how capable the officer will be to make any changes to decisions that have been made. And I guess for me, the question would be, would the expectation be that this fairness officer would be essentially explaining process to the public if they're unhappy with an outcome with ICBC? Or if this fairness officer can truly make sure that outcomes are indeed truly fair, what abilities will this person have to do that if they can't actually comment on outcomes in terms of financial or services. One of the things that's been talked about quite a bit this afternoon is the overall distrust for ICBC, a Crown corporation that has, as has been spoken about a few times today, had a myriad of problems over the past years. But this is not unlike a number of Crown corporations in British Columbia. ICBC, however, has a particularly crucial role to play at times in people's lives that often are life-changing moments. And so an accident that causes serious injury can be a point in a person's life that really marks a very different direction that their life might go. And so the role and responsibility that ICBC has to people is at moments when they are potentially at the most vulnerable moments in their lives. And I think that if we recognize that this Crown Corporation plays this very pivotal role in people's lives, and I think when we debated the bills last year, a lot of us heard many very personal stories about people who had been in accidents and had interactions with ICBC that were less than satisfactory, that left them feeling that this Crown Corporation didn't take care of their needs and didn't serve them at a time when they needed that more than ever. And I'm aware that the minister is making the case that we are going to see a transition from that, but I think it's really important that the changes are being questioned deeply by the members of the legislature. Other Crown corporations, and I just wanted to touch on this a little bit, but there are 29 Crown corporations in British Columbia. And those Crown corporations include BC Hydro, BC Oil and Gas Commission, the BC Lottery Corporation, and Community Living BC. And I think that we might be able to agree that we have some pretty significant and worrying issues with how Crown corporations in BC are operating. And we have this example today of a fairness officer that's being brought in to oversee the processes in claim decisions in ICBC, which indicates that there's been problems with those processes. From the BC government website, quote, Crown corporations are public sector organizations established and funded by the BC government to provide specialized goods and services to citizens. They operate at varying levels of government control and report on their planning, governance, and accountabilities. So publicly funded organizations that deliver services to the people of British Columbia. And I think that what we should be all striving for is that any of these publicly funded institutions that deliver services to the people of British Columbia are trustworthy, are organizations that we can be proud of as a province. But we've seen many examples and instances where this is not the case. There is a worrying lack and loss of trust in many of our Crown corporations in British Columbia. And we have these oversight mechanisms for these Crown corporations, but the Crown corporations don't necessarily want to operate with that oversight. Just recently, for example, BC Hydro refused outright to respond to direct questions about Site C from their oversight body, the BC Utilities Commission. Under the Oil and Gas Commission, we have seen a proliferation of abandoned and orphaned wells. So the regulatory body that is overseeing oil and gas extraction in British Columbia has also overseen a huge proliferation of abandoned wells. Just a few days ago, there was an article that came out. There's an $81 million estimate for orphan site liability from the Oil and Gas Commission statements, which in their own statements say they could go up to $116 million. And I think the people of British Columbia can say, hold on, here's a publicly funded body that is supposed to deliver goods and services to the people of British Columbia, and under their watch, they won't answer questions from oversight bodies. They have allowed these massive liabilities to grow, which ultimately fall to the taxpayers of British Columbia. We have a money laundering inquiry underway in BC, which will perhaps determine to what extent the BC Lottery Corporation did not carry out its duties to prevent money laundering in our province. And so we're talking today about a fairness officer for ICBC, but I think we should absolutely put that into the context of what our expectations of government and government bodies should be in our province. And I want to have the highest expectations. But those expectations, that trust, that goodwill actually has to be earned, it has to be maintained, and it has to be built. And all of these organizations should have at the center of their operations, at the center of their mission, public trust. Because once it's lost, it's very hard to gain it back. And we've heard in the debate this afternoon, the accusations kind of flying back and forth, which government is responsible. Ultimately, I would say we are all responsible for ensuring that these public institutions are trustworthy. And if we are hearing from the public that they do not trust these public institutions, we should take that incredibly seriously. We have a proliferation of oversight offices and officers in British Columbia. It's probably similar in other places, but just off the top of my head. We've heard it today already about the ombudsperson overseeing fair process in government services. We have the representative for children and youth. When I started in 2017, there were close to 80 reports had been written by that office about the operations of Ministry of Children and Families. And those reports have continued to come, and yet we've seen little to no change in that ministry. We have the Auditor General, I think it was 2015 or 2016 Auditor General report on professional reliance and government oversight in the mining industry. Was of great interest to me at the time because of what we were seeing unfold in Shawnigan Lake. Auditor General has also written reports on safety of drinking water in British Columbia, something we should all be very concerned about. We now have the new Superintendent of Professional Governance to oversee the professional reliance model in British Columbia to ensure that the regulators of qualified professionals are carrying out their duties to ensure that the public is being fairly served and properly served. And reports come out from these oversight agencies and offices, and yet we see a lack of urgency to address the very serious and often systemic issues that are identified in these reports. And I think that as we debate a bill like Bill 5 and a fairness officer for a Crown corporation, I think it's important for us to recognize that we might have a larger systemic issue that we're looking at here, which is that our institutions are needing more and more oversight because there are more and more examples of the public feeling that they are not being served by these publicly funded institutions that are meant to exist to serve the public. And so I look forward to committee stage of this bill, and I will continue to advocate for all of us remembering that service to the public and trust of the people of this province needs to be at the center of everything we are doing in here. if it's a small change to an act or if it is a complete overhaul of how a system works, in both cases, we need to be mindful of the people that we serve. Thank you.
Thank you, Member. Recognizing the member for Richmond South Centre.
Thank you, Mr. Speaker. Thank you, Mr. Speaker, for this opportunity to speak. Before I continue, I do want to take a moment to acknowledge I'm speaking to everyone from Coast, Salish, unceded, and unceded territory, and I thank them for allowing us to live, work, and play in their ancestral land. There's a lot of details being shared by both sides of the aisle, and there are many discussions on Bill 5. But if the speakers allows, if you don't mind me entertaining the members within this house with more of a personal story that I would like to share. Obviously, like many members here, when I was young, I first got my driver license. It was an exciting moment. I actually worked and actually paid for my own first car. Back then, my parents taught me to respect and trust ICBC. When we get in a car accident, speak to ICBC. We have an issue, you know what? Somebody might want to address the accident under the table. No, go through ICBC. It's a crown corporation that will put your mind at ease. Unfortunately, a few years ago, while I was in the car with a few of my friends, I actually got into a car accident. And that raining cold night was a night that has changed my life in many ways, and also reminded me how vulnerable an individual member of a population can be, especially people in Richmond South Centre. That night, I actually have my vehicle parked because we're waiting for a light to change. But another vehicle turned and I ran right into my vehicle and was followed by someone else, which just drove right past, didn't even stop. The RCMP came, took notes, and left. I thought this was obviously the other driver's fault, nothing for me to be worried. What happened next truly shocked me to the bone. When I first talked to the ICBC estimator, his first comment was, based upon the accident, based upon your damage on your vehicle, it is obvious you were at fault. I had 3 friends on my vehicle all can look at me and say, we were parked. We were stopped. I shouldn't say parked. I just stopped, waiting for the light to change. How could possibly we be the ones considered moving? And that brought a concern to the ICBC, I guess, caseworker. And part of my language, I didn't utilize the title properly. She mentioned because the 3 friends I have in my vehicle, they're all sitting in my car, so they're ultimately not acceptable as witnesses. But the other driver somehow had a witness who saw everything and provided a full, detailed account of what had happened. That was a raining cold night, and I was in my car. I know the other driver was in the other car. The only other vehicle who passed by, the only pedestrian I saw, was someone who just drove by and didn't stop. The next person was the RCMP officer. As an individual who want to say, I have seen a system that's not working out, who do I speak to? I don't think this is fair the way I've been treated. ICBC told me, we have a commissioner you can talk to. The ICBC staff, they're part of ICBC, you can talk to them, and the individual commissioner will be able to assist you with your concern. That brought fear in my mind. That brought fear in many things I was addressing. One, I had 2 ICBC staff automatically telling me I was at fault without really looking into the situation, despite the fact that based upon my awareness, it's not my fault. At the same time, I wanted to trust this Crown Corporation, but I think we do need a secondary channel that's independent for us to share our concern and to be able to address our issue. When Bill 5 was first introduced, and when I first read the Bill 5, I was relieved. It was something I wish I saw existed a few years ago. Somewhere I can have somebody telling me there's an independent fairness officer whom you can speak to express your concern. I agree with many members who talked in the past. We need to start building trust in our Crown Corporation. We need to start building confidence in our Crown Corporation. And I think when we look at something like Bill 5, even the previous bill, Bill 7, is always talking about proactively building trust, building fairness into our Crown Corporation that we all rely heavily upon. As a person right now, I know as individuals who come to my office, they are already semi-politically aware of what's available in the community. From having my CA assisting them to BC 211 to various different kinds of nonprofit sector support. They know who they can reach out to. But I want to remind everybody, I'm a representative for Richmond South Center riding. A riding that's densely, it's one of the densest riding and one of the smallest riding, and also have the highest population of immigrant and new and young families. And I cannot imagine if I had to deal with something, I was privileged enough to handle the financial burden of that mistake. What other family have to deal with if they don't have somebody who they can actually go into. I'm not asking for the specific detail, and obviously there's a lot of discussion around the detail, talking about the Bill 5. But just asking as an average British Columbians, when they walk into ICBC and they would say ICBC is not fair, wouldn't the fact having a fairness officer available that's independent and appointed by the Lieutenant Governor bring certain amount of relief for the average British Columbians to be able to say we can actually still continuously challenge when we see unfairness, injustice that's brought into our circle. That's the reason why I support Bill 5 and enthusiastically standing here talking to my members. The story, although it ended in me paying the financial burden for it, I was privileged enough to address it. I was privileged enough to know now if the same thing happened again, especially with introduction of Bill 5, and hopefully by May of this year, Bill 5 will become be able to bring us the fairness officer whom we can rely upon, depend upon to express our concern when ICBC's staff demonstrate customer service concern that it's not fair to individual ICBC insurance payers. So if you don't mind me saying, I wholly support Bill 5, and like many colleagues spoken earlier, are there more things to do? There are a lot more to do. Do we need to build more trust for within a Crown Corporation? I would love to see our government who are progressive, continuously putting human rights, putting equality and diversity as a front line to put it forward. We have a parliamentary secretary for nonprofit services. We have a parliamentary secretary for anti-racism, and we're continuously introducing different kind of strategy to bring a fair and safer society for us all to enjoy. So as a MLA for Richmond South Center, and of course a speaker for our people of Richmond South Center, I'm excited to see proactive bill like Bill 7 allowing our residential tenancy branch to address issues proactively, and now looking at Bill 5 talking about it's going to be an independent fairness officer whom we can actually trust enough to actually go talk to when we felt we can no longer trust ICBC or whoever the staff was the front face of ICBC. That's putting us defensively that we seek additional channel. This is a fabulous channel. And I know that some members are talking about financial compensation and injury judicial issues. Of course, we all know there's the Civil Resolution Tribunal who are looking after that component. And of course, ombudsperson would be is still a great asset to our community. But if you don't mind me mentioning to many of my colleagues in here, for individual who's an immigrant or for somebody who's new to our society or who just recently became an adult and working in our community, many of them don't even know what an ombudsperson is. I would be honest with you, shamelessly to be speaking, had a hard time learning to pronounce the word ombudsperson. So I'm just excited and I'm just proud of our government continuously putting people first, continuously finding a way to how we can reduce the fee for ICBC, reduce the rate of ICBC, and finding a way to make it affordable because we're continuously putting British Columbian first to build that trust, to build that understanding, and continuously fine-tune our government service to earn that confidence back that was lost years ago. I'm not going to even talk about a dumpster fire. I'm not even talking about the $1 million executive bonus. I'm not even going to talk about all those. The only thing I do want to emphasize is that we are only heading in the right direction and more work needs to be done. But as long as we continue to follow the right trajectory, I know our government will continuously make British Columbia a fair place, a safer place, a more trustworthy place for British Columbians to grow up, raise their family, and live and enjoy life. Thank you, Mr. Speaker.
Thank you, member. Seeing no further speakers, I recognize the Attorney General. Actually, there is a further speaker, the Attorney General.
Thank you, Honourable Speaker, for recognizing me. I appreciate it. I just wanted to rise and make a couple remarks about the Fairness Commissioner and the intention behind it. I hear a number of members raising concerns about the fact that this is an internal to ICBC office. The Fairness Commissioner is never intended to be an external watchdog. That's the Ombudsperson, that's the CRT. The Fairness Commissioner is intended to be within the organization to help them proactively identify issues of fairness within their own processes. Sometimes in large systems, you can set up a process that makes a lot of sense from an organizational perspective, but from the perspective of a consumer or the person who's using the service, it's profoundly unfair, leaves them feeling like they were not treated well. And it's important to have an office that people can go to and say, this isn't about the money or about the particularities of my collision, but this process that you've set up is ridiculous. And you need to have a look at that. And to have an office that can receive those submissions from the public, provide recommendations to ICBC and to the public, or shared with the public, that provides another level of internal accountability. And I would say it's a basic of a modern corporation, including a Crown corporation especially, to be responsive in that way and to provide an internal, I would say ombudsperson, but we have an external ombudsperson, but an internal process where people can bring these complaints and concerns forward and they can be acted on by the corporation. It's not some kind of a trick that this is set up within ICBC. This was the design. This was the intent for ICBC to proactively identify these issues. I can tell you, having been minister responsible for ICBC, there's nothing more disheartening than learning about a problem with ICBC's processes through the media. Instead, there needs to be a way for them to proactively recognize it and address it before it becomes an issue and erodes some of the trust that a lot of the members are talking about here in this place. It's meant to help restore that trust because the corporation needs to be able to identify problems and proactively solve them. So that is by design. It is intentional. There are external watchdogs to ensure that people are treated properly. But we need to give the company the opportunity to address issues proactively and identify issues proactively, one additional level of safeguard. I just wanted to rise and make that point because I heard a number of members raising different issues or saying, we already have a working process or something like that. The Fairness Commissioner's office was not working. Just was not working as it was structured. And it is an important internal safeguard. That's all, Honourable Speaker. Thank you very much. I'll take my place.
Thank you, Attorney. Now, seeing no further speakers, I recognize the Minister, Public Safety Solicitor General, to close second reading debate. Minister.
Thank you, Honourable Speaker, and I appreciate the opportunity to close second reading debate and to make note of some of the comments that I've heard during the discussion around this particular piece of legislation, the implementation of a Fairness Commissioner, and I think the Attorney laid out very well why we are having this. This is part of the legislative package that we have put in place to make ICBC the public corporation that British Columbians have had pride in for more than 40 years, and at which we have seen over the last decade that trust in the corporation had been eroded. And it had been eroded for a number of reasons. It had been eroded by government policy in terms of, in essence, artificial taxation, if you like, by the removal of ICBC reserves into general revenue for government, and then rates were going up because of this activity. It reached record levels in terms of, people have used the term plundering, the reserves at ICBC to go into general revenue. We saw significant increases in rates. Whenever questions were asked, we were told, oh, don't worry, it's not 14%, it's not 18%, it's going to be 4%. And then after the election, the government at that time was over there, all of a sudden your rates are going up. We saw a corporation that had, operated under social credit, NDP, social credit, NDP, and initial Liberal administrations doing extremely well. We had seen how the 2001 government had set out to in essence, privatize ICBC, and they brought in an expert from, the biggest private sector, one of the largest private sector employers from the Pattison Group to do that. And his recommendation after looking at the corporation was, no. We have something really that works extremely well here. We have something that's well suited to British Columbia. And what we saw after that, though, was this determination to continually to undermine and undermine and undermine ICBC to the point where at the last election, when we outlined that we were making changes to ensure that ICBC remained a public auto insurance agency that was able to provide affordable assurance right across British Columbia, it was, no, you know what? We really need basically to just get rid of it. It's time, why do we have, and the term I think was used, this failed state-owned monopoly was the term that was used during the election campaign. Well, guess what? People rejected that. They rejected it significantly. And the reality is we are continuing the work to do what we said we would do, to ensure that the public has a public auto insurer that is able to provide public insurance at an affordable price. We made some significant reforms, taking the tort system out of ICBC, taking the tort system out, similar to what has taken place in Saskatchewan and Manitoba. And the result has been the ability to give the largest reduction in insurance rates in the history of ICBC. Going back more than 40 years, going back to, I guess, when, I had just started driving. A long time ago, as my colleague says, when I drove my Chevy Nova. Yes. I did not have it when I first started here, but my Chevy Nova, I did have my Chevy Nova, which I was really, that was my car. Anyway, the point being, what we have done is seen a significant reduction in our auto rates. Coupled with that, we have also, because of COVID, said there is a COVID rebate, which is also taking place and which is going out. But May 1st is when we shift to managed care. And that involves a complete change in terms of ICBC, and the focus and the attention is now on the individual in terms of what does it mean to make you better. You have the care that you need. You will get it for as long as you need it. Before, there was a cap of $300,000, for example, if you were in a catastrophic accident and it was your fault. If that split second you made a mistake and you were at fault, there was a $300,000 cap. That's gone. What it means is that if you are injured, you will receive the care that you need, and it encompasses all the different kinds of levels of care, whether it is hospital care, whether it is physiotherapy, whether it is chiropractic, whatever the kind of care it is that you need, you are now able to get. That's what people want. They want to know that they are going to be able to get better, because that road to recovery does not necessarily, some people recover quickly from an accident, others don't. I know there was some criticism in the comments earlier about, what you were going to get in terms of a particular kind of injury. Well, that's very similar to standard policies, but that's over and above the benefits that you get in terms of the care that you need for as long as you need it. And a key part of that is in also ensuring that the procedures and the policies in place that people will be dealing with are fair and that they work. And that's why the Fairness Office is a critical part of that. To be proactive, as my colleague, the Attorney General, said. To be proactive in terms of, hey, this is what we're hearing, this is what we're seeing, here's the recommendations on how we can fix this, here's how we can do this ahead of time. So it's not something that's coming down the road, but rather with in essence, real time. So this is another important critical component of the transference of ICBC to that public insurer that has served this province so well over the years. It will help ensure its long-term, the long-term stability, and this is going to be another component of that. So, Honourable Speaker, I've appreciated the comments that members have made in this House around this. I have no doubt that we will have clause-by-clause examination through the committee stage, and I think that is the appropriate thing to do, and I look forward at that point to answering further questions. But with that, Honourable Speaker, I move a second reading.
Thank you, Minister. Members, you've heard the motion. Motion is to move second reading, Bill 5, the Insurance Corporation Amendment Act 2021. All those in favour indicate aye. Aye. Opposed indicate nay. Motion is carried. Minister.
Thank you, Honourable Speaker. I move that the bill be committed to the Committee of the Whole House to be considered at the next sitting of the House after today.
Members have heard the question. All those in favour indicate aye. Aye. Opposed? Motion is carried. Government House Leader.
Thank you, Honourable Speaker. I call Committee of the Whole Bill 8 Finance Statutes Amendment Act.
Thank you, Minister. We'll just take a short... we'll just wait till staff arrive. Thank you, everybody. All right, members. Recognizing the Minister of Finance. Minister.
Thank you very much, Mr. Speaker. I look forward to questions from my colleague across the way as it pertains to the Financial Statutes Amendment Act. I know that he has a number of questions for us as we go through I believe it's 178 sections, and I look forward. I've got a number of staff with me by my earpiece who are going to do more than whisper sweet nothings in my ear. They're going to help us get through what I hope will be an engaging and elucidating exercise as we go through this reading of this bill.
Thank you, Minister. Recognizing the member for Peace River South.
Thank you, Chair, and also to the Minister, and thank her staff, first of all, who are speaking to her in her head as we go through this virtual stage, and we've done this for a while now. We're trying to get used to it, and I hope the Minister has charged up her earpieces, unlike the last time we did this. There we go. But as the Minister said, there's 178, 179 sections here. We're going to breeze through some of them more quickly than others. It is quite a technical bill encompassing about 11 acts, as we've discussed earlier, and some of the changes that needed to be made around some of the amalgamations into a single, I guess, regulator, if you want to, for lack of better terms in some ways. But I just want to, I guess, basically just start off in the first section here. It's around the Financial Institutions Act in Section 1. And just want to maybe give the minister an opportunity maybe to kind of, as we start off this discussion around the changes in this legislation. Obviously, when I look at the Perrin report and a few other reports that have come forward and discussions around who's been asking for this, the direction and ideas around the minister and oversight and moving it into a single body. I'm just curious if the minister then could just, over the last couple of years, there's been a lot of discussion moving to this. If she can kind of give some background information for people watching of why we're actually doing these changes.
Minister.
Thank you very much, Mr. Chair. Well, this bill before us responds to recommendations from two different groups. The first one is the Perrin report. That's the Real Estate Regulatory Structure Review that was released September 2018. And the second one is the expert panel report that was released May 2019 that supported those recommendations. So we had two different bodies, and they both made those recommendations that we incorporated into this bill.
Member.
Thank you. So when we, I've read those reports, and of course on this side of the House, we're completely in favor of moving towards something that's going to create more fairness, efficiency, and more importantly, something that's going to be, I guess, looked at as trying to solve a lot of the issues that have been addressed through the different reports that we're trying to streamline. The Real Estate Council and others have publicly said that they're in favor of these changes. Have any organizations through consultation said that they're worried or have they been against this in discussions with the minister?
Minister.
Thank you, Chair. I can certainly let the member know that there has been certainly widespread support for creating a single regulator. Having two different regulators has created some confusion. And so the BC Real Estate Association, the Office of the Superintendent, and the Real Estate Council of BC have all acknowledge and support this direction.
Member.
Appreciate that. I'm not trying to throw necessarily softballs to the minister, but it is important to ask some of these questions, even though if we know the answers, to get some of this on the record. So I appreciate that. More specifically to Section 1, which is under the Financial Institutions Act, because we'll get through a couple of these. Can the minister provide an overview of the role of the superintendent of financial institutions and really explain how that is going to fit in now with that position with the BCFSA organization?
Minister.
Thank you very much, Mr. Chair. So this real estate component is joining an existing regulator, the BCFSA, where There is a responsibility for financial institutions, insurance and trust companies, credit unions, and the superintendent of financial institutions. Oh, and the BCFSA, as a larger body, brings an oversight as well for pensions as well as mortgage brokers. And so the superintendents of financial institutions has the subset of the financial institutions that it's responsible for.
Member.
Thank you. Not so much in the bill in section 1, but in the explanatory notes in this section, I had a question just as an example. So it says the superintendent will the power to consent to the acquisition of certain assets by a trust company or insurance company. Can the minister give an example of what that means in the explanatory notes of what a certain asset might be?
Minister.
Thank you very much, Mr. Chair. So an example that the member had asked for is say, for example, that an institution wanted to purchase a major asset, and the asset is worth, let's say, more than 50% of their current assets. Then they have to make, then they need regulatory approval to make such a purchase. And so right now it currently requires that they get this approval from the BCFSA. This proposes to transfer that to the superintendent.
Member.
Is there going to be any supporting office or staff to the superintendent with this move, or will it be amalgamated into existing workloads? And if there is, what's the cost of that?
Minister.
Thank you. There's no more staff required. This just changes the authority.
Shall Clause 1 pass? So ordered. And Clause 2, member for Peace River South.
Just quickly to the Minister on Clause 2, then can she explain the rationale behind removing the minister from this clause?
Minister.
Thank you very much, Mr. Chair. So this actually, in fact, corrects an oversight in the current legislation by removing reference to the minister in Section 23. Since 2004, the minister no longer has a role in providing consents respecting amalgamations, continuances, and arrangements, such things.
Shall Clause 2 pass? So ordered. Shall Clause 3 pass? So ordered. Shall Clause 4 pass? So ordered. Shall Clause 5 pass? So ordered. Shall Clause 6 pass? So ordered. Shall Clause 7 pass? So ordered. Shall Clause 8 pass? So ordered. Shall Clause 9 pass? So ordered. Shall Clause 10 pass? So ordered. Shall Clause 11 pass? So ordered. Shall Clause 12 pass? So ordered. Shall Clause 13 pass? So ordered. Shall Clause 14 pass? So ordered now on Clause 15, member for Peace River South.
Thank you. And I will try to make that a little bit easier for you as we move through this bill. And quickly in Clause 15 here, obviously there's a couple of changes. There's some transferring, there's some reversing transferring. Reading through it, and of course the minister has her staff, but so we can help with this, but I assume, I'm trying to understand this, is this just leaving some of the authority still with the minister and staying the same in corrections? Because trying to understand if the minister could explain that part of it.
Minister of Finance.
Thank you. Welcome, Chair. So this section repeals the current power of the authority to delegate most of its power and duties. The superintendent, as the proposed legislation transfers most of the regulatory powers directly to the superintendent. It also adopts a new power for the minister to transfer the remaining regulatory powers, essentially powers respecting the incorporation, amalgamation, and winding up of financial institutions, to the superintendent by regulation. I think it's helpful for the member to know that this reflects the proposed board governance reforms to generally focus on the authority's board duties on strategic and corporate board responsibilities, general oversight of statutory decision makers and broad policy, in place of empowering the authority to delegate its regulatory powers. The proposed legislation transfers most of the regulatory powers directly to the superintendent.
Member on Clause 15.
Just for confirmation then, from not only from the minister's answers, but going through this, obviously one of the concerns will be that the minister has delegated a lot of authority to a statutory decision maker without necessarily government oversight, and especially in the parent report and others, there was making sure that government still had control, allowed to not only through legislation, but through policy advisement direction to the regulator through that partnership, I guess you would say. So can the minister explain what the role of the minister will be in delegating decisions, or how that conversation process will go dealing with the regulator to ensure that cabinet, government has not relinquished all of its oversight to a statutory decision maker?
Minister.
Thank you, Chair. So I want to make sure that the member understands that what we have before us here is really a transfer of powers between regulators. So this is already really what the transfer is, but there's certainly still the power to bring it back into government if need be. So that is definitely here in this section.
Shall Clause 15 pass? So ordered. On Clause 16?
Mr. Chair, you can go 16 to 33 inclusive, if you so choose.
Through to 33? Shall clauses 16 to 33 inclusive pass? So ordered. On Clause 34, Peace River South.
Thank you. It's my understanding on this clause here, we're talking about some of the criteria. It doesn't look like the criteria, we're talking about freezing of property assets and that. It doesn't look like the criteria is anything's changing. Again, I understand a lot of this is transferring from one regulatory body to another. Of course, a lot of that can get lost through the technicalities of jumbling between 11 different acts. So it looks like it's just the transfer of the authority, not a change I can see, but can the minister maybe explain just so we have that here. When you look at freezing of an asset, what would bring that about, and what would the regulations be or the parameters for, I guess, dispute, I guess, for rather lack of better terms on that as well, just the process around freezing of assets.
Minister.
Thank you. So I want to assure the member opposite that this is, as he pointed out, very much just a transfer of the authority. And in the case of freezing assets, in this case, it's about who's making that decision. And the reason you would freeze assets, again, this is an important tool, gives the regulator an important tool in terms of if there's fraud or some other concern, they need this tool in order to do their role.
Shall Clause 34 pass? So carried. Clauses 35 to 43, shall they pass? Carried. Clause 44, Peace River South.
Thank you, and again, appreciate this. We will move through it quickly because the minister and I both acknowledge that some of this we're just asking to just make sure we get on the record for anybody down the road who might have interest to this. And in speaking with some of the groups, of course, everybody seems to be in favor of moving forward to the single regulator again, as well as this side of the House. But in Section 44, just want the confirmation. I think the minister actually answered this a little earlier on, but it's assuming and assuring that authority, decision-making authority, either revoking or administering, is still within through the Lieutenant Governor, which means through OIC or through Cabinet, that decision-making can still be involved with the regulator.
Minister.
Thank you. So earlier in this bill, we were talking about the transfer of power from the BCFSA board to the superintendent. That was earlier. This particular clause is a little bit different, and this has already existed. And in this clause, it is about the lieutenant governor to take enforcement powers from the insurance council to the superintendent. It had already existed, and here in this clause, what we've done is we've modernized the language and just made it current in today's world.
Shall Clause 44 pass? So ordered. Shall Clause 45 pass? So ordered. Shall Clause 46, Peace River South.
Thank you. So we're getting into a bit of a discussion on the superintendent of real estate, and of course we're talking about the amalgamation, the whole part of this bill. But who's going to be assuming the responsibilities then under this change with the superintendent of real estate in the new organizational structure?
Minister of Finance on 46.
Thank you. Under the BCFSA Act, the CEO assumes that responsibility.
Member.
Is there any discussions, preliminary or otherwise, then through the minister or through the organization, that the roles, responsibilities, or duties are going to be much different between this as we go from two organizations into one? Obviously, we have the real estate superintendent of real estate is, we're just trying to see if there's going to be any difference in the duties, I guess, or roles, and how do they see that going forward?
Minister.
Great, thank you. So there's 3 areas that will be new for the superintendent, and that will be education, licensing, and discipline.
Peace River South.
Thank you. When you say new, does that mean those were not part of the role when we were part of the Real Estate Council when the person was there? So the minister's nodding yes. We can just a transfer of that. So it sounds like the minister's saying just. Do I have that correct? If you want to say.
Through the chair makes it easier to. Minister of Finance.
Thank you, Chair. There's sort of this really narrow part, and it's just sort of nodding. So I appreciate the member speaking clarification. So this had previously been part of the Real Estate Council Authority, and these are the new responsibilities that are being transferred.
Shall Clause 46 pass? So carried. Shall Clause 47 pass? So carried. Shall Clause 48 to 56 pass? So ordered. Shall Clause 57 pass? Member Peace River South on 57.
Thank you, and thank you, Chair, for your indulgence. It is interesting in the House when it's like 2 of us in here almost having a discussion, so I appreciate that. In this section here, going into 57 and for the next few, we're talking about the conduct, complaints, investigations, et cetera, as we're moving forward. So this section presumably relates again to those investigative powers that we were kind of talking about. So can the minister outline how investigations are expected to change as a result of the amalgamation?
Minister of Finance.
Thank you very much, Mr. Speaker. So under the current model, the existing model, the Real Estate Council is responsible for licensee discipline, and the superintendent investigates unlicensed and sometimes licensed, hence some of the challenges. So under the new model that's being proposed in front of us, all investigations will happen under the superintendent.
Peace River South.
Well, thank you. With the consolidation amalgamation, then, is there any extra resources that are going to be given to the group in order to do these investigations?
Minister.
Thank you. So existing staff will be pooled, and so there's not an anticipation of any sort of requirement. However, really, it is ultimately up to the superintendent to make the determinations about what it is that they need in order to deliver on these commitments.
Peace River South.
Well, thank you. And in some of the reports that we referenced earlier, it was talking about policy gaps or some of the challenges that they were facing. That's why the recommendation was to move into one regulator. Can the minister maybe explain what she feels some of those policy gaps were, and maybe just give an example of some of those gaps and why we're doing this? Minister.
Thank you. One of the, I guess, the biggest concern is the potential overlaps in the current model and the current framework. And the unclear authorities of the superintendent versus the authorities of the real estate council. So, for example, the superintendent can investigate or direct council to issue a notice of hearing, and it wasn't clear, and so that would result in a sort of a stalemate or a frustration, and the process wouldn't happen, and that's not. And I know that the member would agree that that's not good public service. And so the more clear we can be around lines of authority, then the better service the public will get.
Shall Clause 57 pass? So ordered. Shall Clause 58 pass? So ordered. Shall Clause 59 pass? So ordered. Shall Clause 60 pass? So ordered. Shall Clause 61 pass? So ordered. Shall Clause 62 pass? Or so ordered. Shall Clause 63 pass? So ordered. Shall Clause 64 pass? Member on Clause 64.
Thank you. It's another amendment. We've seen a lot of this throughout the whole bill here, but can the minister tell us, as we're talking about the disciplinary proceedings, licensing and that in this section here, can the minister tell us for the use of consent orders, will they be substantially changing? Was that recognized as a gap, and is this another one that's trying to solve one of the issues from a report?
Minister of Finance on 64.
Thank you very much, Mr. Chair. So right now, the current limit on acceptance of consent orders at least 21 days prior to a scheduled hearing has not been enforced in recent years. And that's due to the practical advantage and added flexibility of increasing the time to negotiate consent orders prior to convening a hearing. So as a result, this practice is being formally added into this legislation.
Shall Clause 64 pass? So ordered. Shall Clause member on 65?
Thank you, Chair. Transferring power from the, again, on the disciplinary side, from a committee, it looks like, to the actual superintendent, if I'm understanding this section correctly. But how will the disciplinary process change? And how does she see that changing?
Minister.
Thank you. So the proposed amendments allow the superintendent to convene a hearing, either by written submissions or an oral hearing. And this really is about flexibility. This flexibility is to benefit licensees as well as the superintendent, who will be able to consider the requests of licensees and determine which manner of hearing is most appropriate.
Peace River South on 65.
Thank you. Is there any assumptions or knowledge based on the fact where more resources might need to be made available now for this process?
Minister of Finance.
Thank you. Under the, what had been existing in terms of hearings, council members had to sit on a committee, and that was pretty resource intensive. In this new framework, the superintendent, gets to make the determination, and resourcing will really depend on the structure that the superintendent wants to set up for the hearing.
Shall Clause 65 pass? So ordered. Shall Clause 66 pass? So ordered. Shall Clause 67 pass? So ordered. Shall Clause 68 pass? So ordered. Shall Clause 69 pass? So ordered. Shall Clause 70 pass? So ordered. Shall Clause 71 pass? So ordered. Shall on 72. Member Peace River South on Clause 72.
Thank you, Chair. In this section in the clauses, we're going to be talking it's a bit more about real estate agents, agencies, and that. And can the minister tell us how she sees these changing, how that will change the enforcement, I guess, of this? I know there's been lots of discussions in the past years around some problems that needed to be changed, and putting into one regulator might assist in that and dealing with some bad apples, I guess we could say. I think they were referred to in the past. But can the minister then, just talk about the enforcement against unlicensed real estate agents, and will that be changing at all?
Minister of Finance.
Thank you. So as I had mentioned before around the confusion under the model that has currently existed, and what we're proposing here in terms of providing some clarity, under the new discipline model, the superintendent will have carriage over licensed and unlicensed activities. And so that's being reflected here so that there's much more clarity. And I hope that answers the member's question. It's really about making sure that everybody understands who has responsibility for all of these activities.
Member.
Well, thank you. And so with the responsibility now being singularly focused, then is there going to be any increased? Does this increase the tools, I guess, with one regulator as far as enforcement goes, or is this basically again just a transfer of existing policy and regulation around enforcement into one regulator?
Minister of Finance.
Thank you. So this isn't about tools per se. It's really about just having one body and everyone having clarity about who is responsible for discipline in this case, as the member had asked, so that there's much greater clarity and for everybody involved.
Member on 72.
Okay, does the minister, though, have any maybe ideas of estimates around the current level of unlicensed activity that might be taking place in real estate?
Minister of Finance.
No, we don't have any data.
Shall Clause 72 pass? So ordered. Shall Clause 73 pass? So ordered. Shall Clause 74 pass? So ordered. Shall Clause 75 pass? So ordered. Shall Clause 76 pass? So ordered. Shall Clause 77 pass? So ordered. Shall Clause 78 pass? So ordered. Shall Clause 79 pass? So ordered. On Clause 80, member for Peace River South.
Thank you, Chair. Moving
Clause
along quite quickly there. It's almost hard to turn the pages to keep up with you. I appreciate that, though. In Section 80, can the minister tell us the average fine that's kind of levied under the previous sections?
Minister of Finance.
Sorry, can the member clarify the question? I wasn't quite sure I caught the question.
Yeah, thanks. I mean, we're basically changing it now, so the maximum fine can go up to $100,000. So basically what I'm asking is, can the minister tell us what the average fines used to be before we increased it up to $100,000?
Minister.
Thank you, Mr. Chair. So administrative penalties were not often administered in the past, and I don't have, and staff don't have the data currently at hand, but if the member would like, we could certainly get him that information.
Member.
Well, thank you. It's, you kind of went into where I was going next, because I was going to say if they were administered, how often? But if that's the case, can the minister explain the rationale then of if the previous fines were not a deterrent or were not levied, why the increase to $100,000 now as the new fine?
Minister of Finance.
Thank you. Because the scope of administrative penalties is expanding, the maximum penalty is also expanding to reflect that. It's intended to capture those offenses that would have previously proceeded to a discipline committee, where the maximum penalty is $250,000 for an individual, but which otherwise are not contentious with respect to the evidence of wrongdoing.
Member Peace River South on 80.
So can the minister then explain maybe what some of those contraventions would be so people understand?
Minister of Finance.
Thank you. So contraventions can certainly vary in scope. Something as simple as failing to display a sign in a window or failing to update contact information can require some sort of a minor ticket. But there's a whole range, and at the upper end would be perhaps professional misconduct or providing false information to a consumer that would be egregious in some manner that would require a more stringent or tough sort of penalty is certainly required.
Shall Clause 80 pass? So ordered. On 81, Member Peace River South.
Thank you. When we're talking about the contraventions, what types of training or educational penalties are envisioned then under Section 81?
Minister of Finance.
Thank you. As it currently sits, you could only require someone to take education through the hearing process. That was the only place where you could require it. With this change, it makes it also available through an administrative penalty, so that it's another tool to help make sure that licensees, do the right thing by updating and by getting some sort of remediation done through the requirement to take courses.
Peace River South.
Are the courses already available, or is this a new program that's going to have to be developed and administered?
Minister of Finance.
Thank you. Yes, these courses are already available.
Peace River South.
Thanks. Probably know the answer to this, but how do we enforce attendance at these courses?
Minister of Finance.
Thank you. I want to thank the member for his question. So they do need to demonstrate completion with a record of completion that needs to be demonstrated. The other place that it is tracked is the renewal process of their license, which happens every 2 years. So if they didn't get it done, then that would certainly impact on their ability to renew.
Shall Clause 81 pass?
Aye.
So ordered. Shall Clause 82. Peace River South.
Thank you, Chair. And this clause here talks about the superintendent may publish a copy of infractions or penalties. Is that happening right now, or is this a new change?
Thank you. This is new for administrative penalties.
Member.
Thank you, Chair. Is this something, is the thought then to make it searchable online? Because obviously that's something that will be, I think, going forward, will be really important to do, and I'm just curious if that's the plan.
Minister.
So yes, it would be searchable online as recorded by the superintendent in terms of what actions that they've taken.
Shall Clause 82 pass? So ordered. Shall Clauses 83 to 98 inclusive pass? So ordered. On Clause 99. Peace River South.
Thank you, Chair. This section is enabling Cabinet to make and amend, repeal rules made by the BCFSA, and we've brought it up a few other times earlier in the course of the discussion today. It looks like it has the opportunity to provide Cabinet the power to override the rulemaking authority of the BCFSA. Can the Minister maybe give an example of when she feels that would be important to do?
Minister of Finance on 99.
99, thank you. Agent 99.
Gretzky, I was actually thinking.
Okay, so the member asked a question and about cabinet taking action. And if government felt that there was a rule that was sort of contrary to public policy, would be an example. But I also think it's important to point out that this is consistent with the BC Securities Act and the BC and the Financial Institutions Act, recognizing that government does have an oversight role is important, and we've never had to use it, but it's there certainly as a fail-safe in case it's needed.
Peace River South on 99.
So if somebody goes through all the processes after an appeal and they feel everything's been exhausted, does that mean, because of that answer, I'm trying to understand, does that mean somebody can now, at the end, appeal and put pressure, I guess, on cabinet to overrule a decision?
Minister of Finance.
Thank you. So I want to clarify for the member that this isn't about individual cases. This is about a rule that's a policy frame for the regulator. So it's not about individual cases per se, but more about how rules for the real estate operators. Sorry, my mind just went blank. How they operate and how they are governed. So it's much more for the industry. That's the word I'm looking for rules for the industry, and that's what the fail-safe is for, not for individual cases.
Shall Clause 99 pass? So ordered. Shall Clause 100 pass? So ordered. On 101, Peace River South.
Thank you, Chair. Looking through 101 here, this establishes, I believe, establishes a procedure for the BCFSA for adopting new rules, including publications of comment and ministerial consent, actually. So will this rulemaking process be similar to other Crown corporations, let's say like WorkSafe BC?
Minister of Finance.
Thank you. This is the same process as the BC Securities Commission and the Financial Services Authority, so it's not an unusual process.
Member Peace River South.
So what would the process be then for appealing a ruling made by the authority then in a situation like that?
Thank you. I think we have a bit of a language barrier, so I'm just going to get some things sort of clear for the record, and I think that will help. So rules that we're talking about here are like regulations. And if a licensee breaks the rules, then there's a hearing, and then there's evidence, and then there's a decision. And the decision can be appealed. So that, which is like in other places. So I just want to make sure that we're using the same language. Thank you.
On 101, shall 101 pass? So ordered. On 102 through to 125 inclusive, shall they pass? So ordered. On 126, member Peace River South.
Thank you. This section here, 126, is really one of the final things that's needed as far as the dissolution of the real estate council in this section. So I'm just curious what the plan is. So will the members of the real estate council be getting severances? Are they transferring roles and responsibilities? What's happening with the actual council, if the minister can explain that?
Minister.
Thank you. So as the member points out, and I know that the member has done some significant reading since we tabled this bill, and I want to acknowledge his thoroughness because I know it wasn't easy. In this section, it dissolves the council, as the member rightly points out, and it rescinds the appointment of council members. It also contains specific provisions to ensure seamless transition, which I think is really important, to the new regulatory model. And that includes transferring operations, activities, and affairs to the authority, including transferring proceedings related to a decision made by the council under the RESA to the new superintendent, and ensures that rulings, orders, or judgments in favor or against the council may be enforced by or against the authority.
Member on 126.
Thanks. Appreciate that. I didn't quite understand, though, if that meant like the council itself, like the actual seamless transition is fine. But does that mean that the people that were on the council are no longer going to be there? Now that it's going to be obviously with one regulator, and if so, is there severance? Is there any cost, I guess, is where I'm going with this, attributed to moving to a single regulator?
Minister.
Thank you. Thank you. So council members that the member spoke about, they aren't paid. So and staff, and I want to thank you for asking about the staff. They are going to be offered positions in the new framework, so we're not anticipating any significant costs.
Shall 126 pass? So ordered. Shall sections 127 through 179 inclusive pass? So ordered. Shall Schedule 1, 2, and 3 pass? So ordered. Shall the title pass? Carried. Minister of Finance.
Thank you very much, Mr. Speaker. I move that the committee rise and report bill complete without amendment.
Members, a vote is about to occur. If you are voting remotely, please have your cards ready. On the motion, those in favor say aye. Aye. Any opposed? The motion's carried.
Should we have a recess? Mr. Speaker, should we recess?
Committee Chair.
Mr. Speaker, the Committee of the Whole reports go late complete without amendment.
Members, you heard the motion. Please have your voting cards ready. All those in favor indicate aye. Those who oppose indicate nay. Motion carried. Minister.
I move that the committee rise and report. Well, we already did that.
That's done.
It's done. Mr. Speaker, I ask that the bill be read a third time now.
Minister, when shall the bill be read third time?
Now, Mr. Speaker.
Members, again, have your voting cards ready. All those in favor indicate aye. Those who oppose indicate nay. Motion carried. Members, the motion for third reading has been adopted and the bill has passed. Government House Leader or Minister.
I call for a 5-minute recess.
The House will be recessed for 10 minutes. House back to order. Minister of Finance.
Thank you, Mr. Speaker. I call Bill 6.
Committee Chair. Minister, would you please call the bill for the committee stage?
I call Bill 6 for committee stage, Mr. Speaker.
Committee Chair.
Minister.
Thank you very much, Mr. Speaker. We're heading into go clause by clause, committee stage of Bill 6, the Homeowner Grant Amendment Act 2021, and I've got several staff, Jordan Goss, Jeff Henderson, and Jeanette Demanchuk, all in my ear, helping me through, helping us get through this stage of this bill. Thank you, Mr. Speaker.
Thank you, Minister. Member for Peace River South.
Well, thank you, Chair. My apologies, I stood up too soon because you haven't called Section 1 yet, have you?
That's quite all right. Thank you, Member. I would like to ask that we consider Clause 1 for Peace River South.
Well, thank you, Chair. I'm still trying to get used to the new terminology of a clause rather than a section, and so please forgive me if I make that mistake as we go through. You know, we talked about this Bill 6, the homeowners grant, during second reading, and of course a lot of concerns were raised at that time regarding the intentions of government taking in the oversight, if you want to say it, you know, a little bit, changed my terminology from the last bill and Bill 8 that we just discussed, but we're centralizing, as the minister has said, within government. But that created a lot of angst and concern from some people of what the maybe the intentions were of government, why this change was taking place. And of course, this is a good opportunity, as I told the minister during second reading, that I would be bringing up some of those concerns or more pointedly just some of the ideas that people have that they want answers to. So maybe I'll start in the overview section here of really allowing the minister an opportunity to, on the record, to put a lot of those concerns or fears that I've been hearing and colleagues have been hearing in opposition of the intentions of government for doing this. Is the minister able to stand in the House today and confirm that the homeowners grant, as it is, that there's no plan on changing the homeowners grant under her government?
Minister.
I can confirm that to the member, that there is no intent to change the homeowner grant.
Member.
When the minister says no plan on changing, is she talking about the values or just the concept of a homeowner's grant?
Minister.
Thank you. We have no intent to change the program. I do want to point out to the member that we do change the grant threshold. It gets monitored every year to ensure that over 90% are eligible for the grant. That we certainly are committed to, and we have demonstrated our commitment and will continue to be committed to it. But the grant amount will not be changing.
Member.
But just for confirmation, if I understood the minister correctly, because obviously there is a formula built in with the 90%, and so I believe what I just heard the minister say is the intention is that's continuing, which means obviously there will be some people that might fall off the eligibility while others, it moderates, I guess, depending on assessed value of homes and other formulas. So did I hear that correctly?
Minister.
Yes, the member did hear that correctly.
Thank you. I mean, obviously we have people who have concerns right now. When you look at the track record over the last couple of years with this government, with increased taxes and almost penalizing, targeting homeowners with spec tax and other avenues where it seems like this government is not in favor of people owning homes. In fact, the minister's own colleague from Chilliwack spoke in the House just a couple of days ago, and he talked about himself being a Gen Xer, saying that he's probably the last generation to ever own a home. And so that's kind of scary to a lot of people out there when they're hearing somebody from this minister's government saying that, doesn't look like there's a chance for you to own a home in the future, and now all of a sudden we're debating a homeowner's grant. So that's why there's some of these discussions out there. So, I mean, obviously I'll give the minister an opportunity. I'm assuming she doesn't agree with those statements from her colleague.
Minister.
Thank you. What I actually feel is sad that the next generation is feeling hopeless about the opportunity to own a home. However, that has nothing to do with the legislation before us, and our government is taking significant steps in addressing, the development permitting process to make sure that more homes can be built faster in a more collaborative style with local governments. That's why we're putting the biggest investment in housing in BC's history, so that we can help people live in subsidized homes or and even look at affordable home ownership. I know that that's the current Minister of Housing, that's part of his mandate. And so we're very committed as a government to create the kind of housing that people can afford. And that is work that is actively being undertaken after years of neglect. Honourable Speaker, after years of previous government, the previous Liberal government, not paying attention. In fact, I recall in this chamber, the members, when they were on this side of the House, scoffing at the fact that the members from Chilliwack and other members of our caucus, of my caucus, would be laughing at them for their frustration about not being able to own a home, and certainly that's certainly discouraging, I think, for the Gen X and others who would love to own a home, and that work is being undertaken throughout government. However, what's before us, Mr. Speaker, is a grant that has existed for decades, and it's a grant that has been administered municipality by municipality with no coordinated effort, and it's burdensome for local governments. It's a piece of administration that they have undertaken, but it's a significant piece of administration, and it's through their conversations with local governments that the opportunity presented itself that what if the province undertook that administration, given that we're already doing that for rural property owners and administering a grant, and this is an opportunity to relieve the burden from local governments. And I have to say, Honourable Speaker, local governments really are thrilled at this. It's one less piece of work that they need to do. This way it's centralized. This way it's easier for people to get a grant. If they have any questions, it's one phone number for the entire province. They can get the same information rather than 162 different local governments administering the same grant program. So this really simplifies it for local governments, and it simplifies it for homeowners as well.
Member.
Well, thank you, Chair. I mean, obviously the line of questioning I have at the beginning will expand into some of the things that the minister has brought up earlier. But there's over 1 million people in the province of British Columbia who have worked very hard throughout their lives, some making a lot of sacrifices in order to own a home. And for some, part of affordability and being able to afford that home is the reliance on the homeowner's grant, which is why I think it's important that we acknowledge that. So will the minister agree with that statement at least, that the homeowner's grant is actually a part of affordability to help people get into homes?
Sure.
Yeah, thank you, Mr. Chair. I think, you know, the homeowner's grant for sure is part of affordability, just as affordable childcare is part of affordability. We give grants to families, making sure that they could put their children into care, professional care that is affordable to them. Just as affordable housing is a part of affordability, just as you know, other opportunities for families to get to access, you know, mental health care. Is part of affordability when it's provided as part of our healthcare system. So there's lots of ways in which we drive affordability. Again, this legislation before us is not about changing the grant. It's just about where it's going to be administered. So there is no intent to change the grant.
Shall Clause 1 pass? So ordered. Shall Clause 2 pass? Member for Peace River South on Clause 2.
Thank you, Chair. I have a few questions here on Clause 2. Part of it's talking about, it says about the expansion, if there's a breakdown in marriage. And actually, before I get started, my apologies. Before I get into 2W, I do want to talk about 2E, which is around Vancouver. I should actually try to get that one from the minister on the record, just to clarify, because obviously most people know that Vancouver has its own charter, which can create some interesting dynamics, to say the least, when we're trying to make changes like this. So how is this going to affect the city of Vancouver as far as the homeowners grant? Are they still going to be dealing with it themselves, or is the province taking it in?
Minister.
Thank you very much, Mr. Chair. So as the member wisely pointed out, Vancouver does have its own charter, but they are, however, going to participate, and the province will be administering the homeowner grant for those people who call Vancouver home.
Member.
Later on in this section, in Section 2, it talks about, again, the breakdown of marriage. And so I'm just kind of curious, can the minister tell us what the intention of changing the definitions in W are? You know, is it expanding or contracting the definition of what a separation would be? For eligibility purposes, obviously, is why we're talking about it.
Minister.
If the member can just clarify Section 2, was it W?
Member.
Just to clarify, I'm referencing Section 2 in the Act, or not in the Act, sorry, my apologies, in the bill. Okay, and so if the member looks at Section 2 of the bill, and so that actually goes to Section 2, which is Section 1, which is being amended subsection W.
Thank you very much, Mr. Chair. So this amendment eliminates the requirement for a written separation agreement and substitutes that requirement with the requirement that the separated spouses continued to live separate and apart for at least 90 days due to a breakdown of their marriage or marriage-like relationship in order to be considered separated. The amendment changes the policy on how to determine whether a person is no longer a spouse. However, a transitional provision has been included to allow both the former and amended definition to apply for the 2021 tax year. This provides flexibility for how separated spouses qualify for grants during the 2021 tax year.
Member.
I can see why the minister's asked me to define exactly where I'm referencing, because she has some very well-written notes that her staff has helped her on, obviously, with that. So I appreciate that answer. Does she know, is this definition, or what the minister just read out, is this similar with the Speculation Tax Act?
Sure.
Thank you very much, Mr. Chair. So this amendment ensures that consistency with the Family Law Act and the Income Tax Act as well. And it's similar to the speculation and vacancy tax.
Is it similar in the way that this is the similar criteria used for applying for an exemption from the speculation tax?
Thank you. For the speculation and vacancy tax, you have to be living together for 12 months. However, under this one, it's 2 years. That's the difference.
Member.
And there were changes, though, that we talked about around the definition of separation, as the minister said earlier, on the 90 days and all that. I guess one of the questions that's been coming to me and to our colleagues is the government going to be using a similar lens that they use for the vacancy, for the use of the home for the speculation tax, and start looking at applying that with the homeowner's grant for the eligibility?
Thank you. I'm not quite sure I understood the question, so I'm going to ask if the member can re-ask it so that I have clarity.
Member.
Well, right now, there's certain criteria when you're applying for the speculation tax, right? And there is certain criteria you have to fulfill in order to be exempt from the tax. But a lot of that is this government's put in the use of the home. If you're in there for more or less than 6 months, and there's a lot of other criteria that's been built in under the speculation tax. So, of course, some people are saying, well, maybe I'm in a zone that right presently isn't part of the speculation tax, but I own a home and I have the homeowner's grant, but I'm only applying for that homeowner's grant, but I maybe am not in it for the 6 months of the year because they do other things. Is this going to open the door now, as the minister said in her opening remarks, they're worried about fraud, but they're also worried about, or considering, gathering this information for future uses. And so some of the concerns that I'm hearing are people say, oh, so if I go away down to a place that I have, let's say in Arizona in the wintertime, which hopefully people can get to do again someday, and my home possibly may or may not be vacant for a certain period of time, but I'm outside of the spec zone area, so I don't have to worry about that. But now all of a sudden the government's going to start looking at this information through application possibly. And so that's just some of the concerns I have that people have been giving to me. So I guess I'll wrap that up for the minister by just saying, is the minister looking at using the similar criteria around the homeowner's grant? And I'm sorry if I'm not explaining it well for the minister to find this, but we want to ensure that we're talking two separate things here. And the minister has said in her opening statements that, as this gets centralized, government's going to have more and more information, and we'll get into the whole social insurance number conversation probably later. But again, it's just trying to ensure that the lens that's being used around the homeowner's grant is, I guess, going to be separate from how the government uses criteria for the speculation tax. Does that help the minister at all?
Minister.
Thank you. I appreciate the member getting back up on his feet and providing a little bit more context to the nature of the question, because in my mind and in our government's mind, these are completely separate pieces of legislation with completely different purposes and aren't related at all. And so, the speculation and vacancy tax is around speculation in investment properties and making sure that people are using the homes for what they're intended to be. And the homeowner grant is a program that is an institution here in British Columbia, and there's no intent to do anything with it except to centralize the program. As I have said before, this is something that has been talked about with local governments. They've been responsible for all these years for administering the grant program. As well, the UBCM has been consulted. They're eager to see this happen. This is something that was announced back in 2020, which feels like a million years ago now, but really it was just, it wasn't that long ago. And several pieces of work have been done to get us here. Some transition work has been done so that we can start making that process happen. And this is the final piece to put it into the legislation so that it's got clarity going forward.
Shall Clause 2 pass? So ordered. Shall Clause 3 pass? So ordered. Shall Clause 4 pass? So ordered. Shall Clause 5 pass? So ordered. Shall Clause 6 pass? So ordered. Clause 7 pass? Member for Peace River South on Clause 7.
Thank you, Chair. Just want to give the minister an opportunity to help clarify a few things here. Obviously, the government works on a fiscal year. Taxes collected, from what I remember, based on a calendar year within a municipality. And so how do we square this circle? How's that going to work?
Minister.
Thank you very much, Mr. Speaker. So there are no changes based on the calendar versus fiscal year. This has been how this program has operated through all of these years, and there's no accounting changes that need to happen as a result. It's the exact same process as we've seen through local governments. It's just the administrator that's changing, which is the provincial government.
Member.
With the administrator changing, I'm just trying to understand. Let's just say it's a home sale, and they work out on a 1/12th of a year. Of course, if you buy your house in February, you have to pay 2/12ths of the expected taxation for that year. But there's, the conversation now around the homeowner's grant. I'm not sure if the minister can explain that to me, and I may have this wrong, but when you do sell a house, again, you're subject to having to pay part of the taxes on the house. Is that application now waited until this, later on in the year, and somebody's applying for the homeowner grant to the province, and that'll be separate outside of a sale of a house? Because now that'll be done by the homeowner, and somebody will be paying the full tax amount?
Minister.
So thank you, Mr. Speaker. So this is a conveyancing piece that the member was speaking to, and it doesn't change from the way it currently exists under the current framework. The only thing that changes is, again, who's administering it, and instead of local governments, it'll be the province.
Shall clause 7 pass? So ordered. Shall clause 8 pass? So ordered. Shall clause 9 pass? So ordered. Shall clause 10 pass? So ordered. Shall clause 11 pass? So ordered. Shall clause 12 pass? So ordered. Clause 13, member for Peace River South.
Thank you, Chair. I didn't score a goal, but okay. I guess on section 13, I'm just trying to get some clarification on bringing this into government. How is this going to, I guess, either add to or remove the red tape component of applying for the homeowner's grant, especially when you look at, you're going to have more records keeping. You've got, in this section here, we're talking about a lot of changes, it feels like. So is there more red tape that's going to be maybe not necessarily seen directly by the homeowner, and I'll talk about some of that after, but I'm talking from a government perspective of how they're going to roll this out.
Minister.
Thank you, Mr. Speaker. So this section here really is a modernization of the Act. It's really about clarity and readability for the taxpayer. So just for an example, in this section, we're replacing the word supply with give. That's sort of simpler language. The other one that caught my attention was documentary evidence. What it means is records. So this is really about simplifying the language, doing our best, I think, Honourable Chair, to make the work that we do here as legislators a little bit more readable, and so that when the public goes online to take a look at the laws, they have an easier time understanding what it is that we're meaning, and using simpler language is what's here in this clause.
Member.
Well, in section 13 of the bill here, so section 5.4 of the Act, which is what we're talking about, it also talks about the request from the grant administrator I'm reading out of the bill here, for an eligible person must give the administrator any information or records that they require. What kind of records would that be, and who's he asking of those records of?
Minister.
Thank you very much, Mr. Speaker. So in this instance, I think the member is referring to records that would need, an administrator might require if there is an extended absence from the principal residence. And in this case, if someone has gone into long-term care, for example, or into a hospital for an extended period of time, or even gone away to school, they would just need to provide evidence that that's in fact the case, so that that could be acknowledged, that it's still their principal residence.
Member.
So I'm assuming the minister is acknowledging that this is not something that's just a change, or sorry, something that was done before, because the minister said really nothing's changed, government's just taking it in, but that sounds to me like this is a new piece that's been added.
Minister.
Thank you, Mr. Chair. This has always been the case. This amendment does not change the scope or the objective of the existing provision. It's just really a language change.
Shall Clause 13 pass? So ordered. Shall Clause member for Peace River South?
14.
Clause 14.
Thank you, Chair. Section 6, subsection 6.4, or C4 here, there's been a repealing and a whole section being substituted in. I'm wondering if the minister can explain what the change is, and I'll help the minister here by, it's talking about a person is not entitled to a grant and is not eligible for the supplement in respect to the property taxes imposed, and it goes on. And so this is a new substitution into the act. And so what was the intention of this? What's being changed?
Minister.
Thank you very much, Mr. Speaker. So there's a number of modernizing that happened in this clause. It's not new. There's nothing new here. It improves the flow of how the sections are arranged in the Act so that it reads better, as well as really just clarifying, because a lot of this, I think we need to keep in mind, a lot of this legislation is much older legislation, and having the opportunity to make it more readable, I think, is the opportunity that we're taking here as well.
Shall Clause 14 pass? So ordered. Shall member for Peace River South on Clause 15.
Thank you, Chair, and acknowledge, this Act is, a big portion of this Act originally, I think it was 1996, if I remember. For a lot of it, it's had a bunch of changes along since the days and started in the 70s. There's been a lot of things that have fluctuated. And the minister acknowledged that at the beginning, that this has been going on for decades, really. Just wanted to put that there, but on Section 15, and I'm not trying to wordsmith by any means, but I look at these, and I know staff can help if the minister doesn't know the answer to this one, but I always wonder why we would look at something like this, and that's changing a word from somebody who's eligible for a grant to somebody who's now entitled to a grant. Why is that change needed? So there must be a difference of what we're trying to accomplish here, or maybe, as the minister said, clean up terminology, but why would that be changed to entitled now and no longer eligible?
Minister.
Thank you very much, Mr. Speaker. So the term eligible has been used to describe both grants and supplements. However, in other parts of the Act, entitled is used in reference to grants. So really what we're doing here is just making the Act internally consistent, so we're using the same language throughout. Yeah.
Member Saanich North and the Islands.
Thank you, Mr. Speaker. I've been frantically waving my arms around here.
Apologies, member. Apologies.
I had a question for the minister a few sections back, but perhaps it can just provide some clarity on this. And it is kind of along the lines of just seeking clarification to what member from Peace River South was asking about earlier, and just the minister's response to now Section 13, but formerly Clause 13, was that there's nothing new is happening here. It's just simply granting the power from the former body that was doing this to now the provincial government. I just want to be clear that the information that's gathered by the grant administrator, or the information that was gathered by the municipal government, was always came to the provincial government. It was always information that the provincial government had, that we're not changing who holds the information necessarily. It's just who has the right to collect it. Am I correct in that?
Minister.
Thank you, and I want to welcome the member It's nice to look up and see him up on the big screen. I want to reassure the member that this has always been the case as a grant administrator, that hasn't changed in terms of what information the grant administrator has been able to ask for. That's exactly correct.
Since I can't tell, I'm just going to ask the member for Saanich North and the Islands if there's another question. Nope, okay, we'll continue on. All right, so back to section 15, clause 15, apologies. We're still working through the terminology. Many of us have said section for years and years and years, but to provide greater clarity, we're going with clause, and we'll see how that goes. Shall clause 15 pass? So ordered. Shall clause 16 pass? So ordered. Shall clause 17 pass? So ordered. Shall clause 18 pass? So ordered. Shall clause 19 pass? So ordered. Shall clause 20, member Peace River South on clause 20.
Thank you, Chair. I think this section gives me an opportunity just to kind of put a few things out there. We're talking about the grant applications themselves, and I'll have a few questions that I'll want to get into. But some of the challenges, obviously, that we want to highlight and face is the minister in her opening remarks, and as we're talking about the consolidation to bring this more wholly into government, is the online component of applications. And so some of the concerns we have, and not to necessarily get too political on some of the other application processes that have happened recently that haven't necessarily fared as smoothly as promised. There are a lot of concerns out there, especially in the elderly community, and right or wrong, a good portion of homeowners are people in the older years. And so I've been hearing from many that they're concerned about the fact that, this has been something where people have been able to just go into the city hall, the town hall, fill out the application, check a couple of boxes, didn't really have to apply, supply any other information, really. Check 2 or 3 boxes, sign a signature, and then pay the balance. So there's a lot of confusion out there now on how this is going to roll out. And so I want to give the minister an opportunity maybe to be a bit more clear for people to help with this. And I know there'll be opportunities later, I'm sure. But for somebody in my riding, when they go into City Hall to pay their taxes because they're not paying through a bank or online, how's that process now going to look? Is the city going to say, did you fill out your homeowner's grant already? And now are they going to have to check something at the City Hall to say, yes, they have, so they know how much to pay? And if there's a misunderstanding, what kind of follow-up is there going to be? Or are we going to have a bunch of people on July 2nd, after this is all done, all of a sudden with penalties maybe accrued because they only paid a certain amount, not counting a homeowner's grant, without filling out the proper forms?
Minister.
Thank you, Chair. So first of all, I think it's really important to recognize that there will be two processes that people can choose in order to claim their homeowner grant. One is online and the other is over the phone. I do want to point out, and the member talked about, people walking into their city halls. And I have to say, and we both come from local government, so we've certainly heard the complaints, and I don't know if the member has had his share of complaints around the long lineups at City Hall in order to pay property taxes and the frustration that comes with waiting in line physically in buildings. So that doesn't always work well either. But I do recall when my community went online for paying property taxes, which was when I was in local government, it made a huge difference, and people were incredibly grateful to not have to get into a lineup in order to pay their taxes. But over the phone is not something that most municipalities offer. So as a province, we have we'll have two methods for folks to do that. And there will be, a wide range of time for people to actually make the application, so it's not the bolus effect that I think we see in some programs won't be won't be the same. The other thing that I think is important to recognize is that many municipalities like mine are already online, so it's not going to really change much. So when people will get their tax notice, it will say on the notice to claim your homeowner's grant, you can go here, you can call, so that people can do it those two ways. And I also want to let the member know, and anyone else who's watching, that this is currently in operation for rural taxpayers because they don't have a municipality to do the homeowner's grant. So it's an existing system that is certainly capable of handling the changeover to all properties.
Member Peace River South on clause 20.
Thank you, Chair. Just if the minister can clarify on her last point, and then I just want to ask a few more questions further on this, though. But what is the process right now for regional districts? Because as my understanding, it's not necessarily just online, that people can still fill out the form, drop it off at the regional district office, or mail it in, that it wasn't just an online system. And the reason why I say that is I know, just like many people in this House, a good portion of my rural part of my riding, there's no such thing as internet. So they're unable to do it online. So it kind of defeats the purpose if they have to drive to the town hall to borrow a computer to do it online. So I'm just...
Minister of Finance.
Thank you. So I appreciate the member's query, and that's why we do have a telephone application. And last year, for the rural areas, there was only two ways to make an application for the homeowner's grant in rural British Columbia, and that was online and over the phone, and it worked quite well.
Member Peace River South.
Are those the only two options that are going to be available this year then for people in the first year? I say that because I do acknowledge the minister's comment earlier where she was saying a lot of municipalities have gone to online, and yes, it has been very successful. I know in mine and others that option, the municipalities in fact to try to curb their staff costs, it was quite a large push to do it online. But online right now means going to the municipality as the collector, I guess, under the terminology, I assume. And so I'm just curious if there's going to be any flexibility, just to follow up on my first question on this section, flexibility in this transition year. Because back to that point, the lineups are getting smaller because of online, but it doesn't work for everyone. And phone lines, as we've seen, don't necessarily always work for everyone. And so I'm curious in this first year, is there going to be any flexibility, or is it going to be pretty stringent on these are your only options, and if you don't hear about it, follow them, then you've lost your chance to claim the homeowner's grant.
Minister.
Thank you, Mr. Speaker. Phone and internet are the two options. Phone is, because we'll have the two options simultaneously, because we also already have so many people comfortable with internet, given the municipalities have been doing that for 10 years, maybe longer. The rural areas have already, adjusted. We're not expecting to see that many challenges, and that's why we have phone. The other thing I think is important to recognize is that by phone and using the internet, doing it online application, you can get a near immediate adjudication. Right, it's done. Whereas with mail, and God bless Canada Post, but sometimes it can take a while, and not having reached anyone, not getting a confirmation of any kind that you've submitted your grant. People will be left not knowing, and that creates a different kind of risk in terms of potential late penalty fees. So moving to a system that can adjudicate more efficiently, and people can get back a number that says that they're confirmed, will certainly ease angst that some people might feel in making the application.
Member.
Thank you, Chair. Appreciate that. It didn't quite answer completely, though, one of the questions I have, because it was what happens if people fail this first year in this transition year of this change. It sounds like we're taking everything away from the municipality. I assume that's the case. There's not going to be any role for municipality other than telling people when they come in for their homeowner's grant, you came to the wrong place. But I still have concerns, again, as we've seen, applying online doesn't always work instantaneously, and phone lines don't work instantaneously, as the minister just said. And so that I'm just trying to confirm, is this, how hard fast is this going to be this year for the transition year for so many, I'll say seniors mostly out there, who are so used to doing it a certain way, and there's going to be some obvious confusion with the change. And so now all of a sudden, as to my earlier point, the cutoff July 2nd, I believe it is. So, at the end of that day, they didn't apply for their homeowner's grant. Is there going to be an opportunity for them to get a hold of the province? Or is it going to be, sorry, you're paying your full taxes now and you're not eligible?
Minister of Finance.
Thank you very much, Mr. Speaker. When I think about how my homeowner grant operates in my city of Coquitlam, the fabulous city of Coquitlam, typically, get my tax notice sort of late spring. Municipalities have until, I believe it's the end of May to get their tax notice out. And then it usually sits by the computer for a little while until I figure out, decide it's time to do bills or whatever, and I do what I need to do. And you have really until July to get it done. With this change, Honourable Chair, there's a number of things that I think are an incredible advantage. So not only will there be a notice about where to go for your homeowner grant when municipalities send out their tax notice in May or earlier, but people can even do it now in the tax year. So they can actually go online, www.gov.bc.ca/homeowner grant, all one word. And they can make their application today. I want to encourage the member when he leaves here, perhaps he might want to take advantage and not have to wait. But so there's a real breadth of time for people to take advantage of the opportunity. I'm not going to read out the phone number, so there are many days in the year before July 2nd when people can make the application, and it doesn't have to sit by their computer and hope that they remember to get it done in time. So, this is again consistent across the province. So anyone anywhere in British Columbia can make an application through the same portal, the same phone number, and get the information that they need and submit their homeowner grant application.
Thank you, Minister. For those of you participating remotely, if you wish to speak, please just send a little message to our very capable table officers, and they'll be happy to pass the message on to me directly on Bill 6, Section Clause 20, Saanich North and the Islands.
Yeah, thank you, Mr. Speaker, and thank you to the Minister for responses to this. I think that it's an important opportunity that we're taking here to ask these questions about how this program is going to be delivered. And just along the same lines as the line of questioning from the member from Peace River South, just wanting to, again, just ask the Minister questions around the scalability of the services and the robustness of the services that the provincial government is prepared to provide for this. And if there are any additional resources that are being put into place, we have seen, and the member from Peace River South noted it, and certainly my constituency staff are noting it from the number of people that are contacting us. But the delivery of some of these programs and grants that British Columbians have been applying for has not been as smooth as I think the government would have liked it to be. So I just want to make sure that the provincial government is resourcing and your ministry is resourcing appropriately for scale, because I think it's one thing to say regional districts, residents living in regional districts have been able to do this and that we've got some experience. It's another thing to say that all homeowners in British Columbia will be using this service. So I just want to make sure that we've taken the appropriate measures to ensure that we got the right kind of bandwidth, the right number of people answering phones, and that when British Columbians are given this task of changing how they do things, that we're going to be there to be able to provide the support that they need, and that it is as easy as is being articulated in your responses previously.
Mr. Finance.
Thank you very much, Mr. Chair. So certainly with a change in a program, there is an expectation that there will be an increase in call volumes, and staff are prepared for additional call volumes. They'll certainly be open. They'll certainly be available. Oh, and the system is open to apply now. I could read into the record the link again if the member is interested, gov.bc.ca/homeowner grant, all one word. But what's really interesting and I think is helpful for the member to know is that with the speculation and vacancy tax, we processed 1.6 million applications. That gets adjudicated and moved through the system online. And with this program, it's 1.1 million. So there's certainly comfort with that kind of volume among staff. But given that it is a new program, they are going to be looking at additional resources to help with the phones and help people adjust to a new system. And they recognize that they'll be needing a bit of extra support, but they're also confident that they'll be able to address the needs of homeowners.
Sandwich North and the Islands with a supplementary.
Yeah, thank you, Mr. Speaker. Has the minister and the Ministry of Finance put in place any backup contingencies for if the call volumes and the recognizing that there is quite a large window, and I think that, but it is important. This is the time to ask these questions. That the ministry has put in place any contingencies in case they're overwhelmed, and that there's a fallback plan to be able to provide the service for British Columbians.
Finance.
Thank you very much, Mr. Chair, and I thank the member for his question. And given that we've run some very significant programs, biggest programs you've ever run, and there have been absolutely hiccups and challenges with that. I certainly appreciate the query, and staff do have a backup for added support. So there is a contingency that internal resources will be seconded in order to provide additional supports should they be necessary. And so that's what we've done certainly over the last number of months, and so people are well prepared going forward with this new program.
Sandwich North and the Islands.
Thank you, Mr. Speaker. This is well, I don't want to get into counting because I might miss some, but there are now a number of different times in which a homeowner or a property owner is now registering with the provincial government, and the provincial government is collecting information from British Columbians about the property that they own and or that they have interest in. I'm just wondering if the ministry has considered streamlining that process in order to remove some of the burden. I know that we regularly get concerns raised by our constituents with respect to the speculation and vacancy tax as an example, and now the homeowner grant is coming to the province. Is there any work being done within the Ministry of Finance to streamline that process for British Columbians, where they can, where perhaps the number of times that we're requesting information can be all brought into one place and easily determined what programs that they're eligible for or entitled to, depending on which language you want to use. Has there any of that work been done within the ministry? It seems like we're now setting up a second process for this.
Minister of Finance.
Thank you. Thank you very much. I want to thank the member for the question. And government is I want to stress, is always looking for ways to streamline for citizens, always looking for ways to make it more efficient for people so that when we ask for information, we only need it once. These two programs, and the member had mentioned, was the speculation and vacancy tax. They're very different programs. So the speculation vacancy tax, when you get your form for 2021, it looks back to 2020. And your homeowner grant is what you get for 2021 is for 2021. And so it's really, they're each looking in different directions. But I certainly appreciate the member, addressing and asking the question about streamlining. I think it's really important that we continue to do that. And I certainly look forward to ongoing conversations about ways that we can be more efficient, which not only saves staff time and resource time, but also time for citizens as well.
Sandwich North and the Islands.
I think of a number of different ways that the government collects and holds information about citizens and residents and property owners and all the different variables, and just think of it in terms of a database that could be used for multiple different purposes, whether it's looking forward or backward. It's just information being held that could be applied to different programs. And if a resident or a property owner, constituent, citizen of BC had access to their profile, and they could have in front of them all of the different programs and services that that British Columbia government is that pertains to them, that they could do it all in one place. And it's not, I think, lost on anybody in this house that with every new process that we put in place, not only is there the administrative challenges of delivering that service, but there's also the financial realities of putting that structure in place. And what it sounds like is a separate structure for one program, and I recognize I'm not trying to suggest that these programs are the same. They're not. However, they are. The BC government takes actions based on the information that they gather about these programs, and so I'm just thinking that we're setting up in this and probably to be more efficient, setting up a system that the provincial government houses the data collection of this, and I'm just wondering what is the cost to setting up this or making the current system, as the minister's already noted, that the provincial government does this already to some extent, but what is the cost of expanding this service to British Columbians?
Minister of Finance.
Thank you. Thank you very much. So the member asked about costing, and so any specific costing, I invite the member to join us in estimates, because I think that's where we're going to have that discussion, and I look forward to that. But I want to assure the member that the Ministry of Finance is leveraging existing resources to centralize this information.
Sandwich North and the Islands. I assume you're good.
Yeah, sorry, that's it. Thank you.
Thank you. On Clause 20, Kootenay East, please.
Well, thank you, Honourable Chair. Just a couple quick questions here. The Minister, through you, Chair, of course, the Minister was recently quoted saying there will be rigor to homeowner grant administration to help fight tax evasion, reduce fraud, and ensure people are paying the right amount of tax, unquote. Through you, Chair, to the Minister, can the Minister tell me how will this new process do that? Sorry, Chair, and what has local government not been doing that the government now is going to be doing?
Minister of Finance.
Thank you, Mr. Chair. I thank the member for his question. Currently, when municipalities process the homeowner grant, they don't talk to each other about or share information, of course, as two separate municipalities. So there certainly is the risk, because they don't have access to each other's information, that someone could claim the homeowner grant in two different municipalities, and there's limited ways in trying to sort that out because you're only eligible for one home. And the other, other information, I'm anticipating what the member might be asking is through the social insurance number, we can confirm eligibility requirements like citizenship and permanent residency. So it's just a way to make sure that those that are eligible are taking the opportunity to make use of the homeowner grant. That's who it's for. And these are things that we can put in place by centralizing it. We can make sure that eligibility requirements are being met, and that we don't have people taking advantage of the fact that we have an uncentralized system where we have 162 different local governments administering the same program.
Member for Kootenay East.
Thank you, Honourable Chair. Well, the Minister, through your Chair, said some interesting things, and that is sharing information, streamlining, tying information together via a SIN number. And the Minister may know that the SIN number is a federally issued number, a personal identification number for residents. And that number is, its purpose is not as an identifier for tax evasion or fraud. It's for benefits and employment through Canada. So using this identifier for tax evasion, fraud, streamlining, bringing information together may be in contravention to what the SIN number is intended for in the first place. Can the Minister tell me what her thoughts are about using a SIN number as an identifier?
Minister of Finance.
Thank you very much, Mr. Chair. So I want to make sure that the member understands and appreciates that the social insurance number is a common identifier for many tax programs, not just for income tax program, but certainly for the property tax deferment program, for the speculation tax program. This is not an unusual component of making sure that eligibility for programs and using it to identify which citizens or permanent residents are making applications.
Member for Kootenay East, supplemental.
Yes, Honorable Chair. Well, that's interesting. We've seen this process in place for many years. Regional districts, local governments, municipalities, BC Assessment has never used a SIN number as to identify. And I'm seeing this shift now going over to government. I'm wondering, is this the main thrust of how you're going to eliminate fraud or reduce, from your quote here, reduce fraud and ensure people are paying the right amount of tax? Is this what government is saying is going to be the magic bullet that's going to prevent this?
Minister of Finance.
Thank you very much, Mr. Chair. So I guess the short answer to the member is yes, it was a commitment made in 2018 30-point housing plan to reduce fraud and tax evasion. We certainly have recognized that there have been certainly some challenges, and we want to make sure, and I know that British Columbians want to make sure that the homeowner grant program is protected. That's a value. I know that the member opposite has certainly canvassed that, and it deserves to be protected. It really helps families, it helps seniors, it helps people with disabilities stay in their home. It's a really important part of what we have here in British Columbia. But I know that British Columbians also want to make sure that those who are truly eligible are the ones who benefit from that, and that it's important that we do reduce fraud and tax evasion in a program like this, and I can't imagine anyone not being happy with that. Thank you very much, Mr. Speaker.
Your mic, but okay.
Peace River South.
Sorry?
Oh, okay. My apologies. He was waving. I thought he was done. If he still wants to go, we can let him.
Oh, Peace River, go ahead. Peace River. So I'll go back to Kootenay East after. Go ahead.
Okay.
Thank you.
Thank you, Honorable Chair.
Yes, Kootenay East. We'll wait one moment. We'll do with Peace River South. We'll come back to you. Thank you.
Thank you, Chair, and I appreciate everybody's flexibility as well with Hansard. Thank them for understanding and being so flexible as we're trying to maneuver through this too. So we'll go back to the member from Kootenay East. I guess all I was going to ask in that same line to the minister keeps referring to the fact that we need to look at stopping fraud and curbing fraud. Now, there's no argument, I don't think, from anybody in the House for that. But when the minister keeps referencing it back to the homeowner's grant, there must be some data. So how many people have actually claimed the homeowner grant twice and committed fraud, as the minister would put it, that we're now going to be able to stop?
Minister of Finance.
Thank you, and I appreciate the member's question. We estimate that it's about 3% based on some audit samples.
Member for Kootenay East.
Thank you, Honourable Chair. I just wanted to go back to this SIN number issue here. The member from Saanich North and the Islands kind of alluded to it, and he looked at retrieving or collecting personal information from people would be great to probably have it all in one place, to have access to a residents' profiles, as he put it. Unfortunately, there's a lot of people that don't want their personal information accessible to others. So I guess the question through your chair to the minister is, how does the ministry or how does the government plan to store that personal information?
Minister of Finance.
Thank you very much, Mr. Chair. And I appreciate the member's question. The storage of personal information is absolutely critical. And we will be storing this information in our tax administration system, where we currently store other tax information.
Kootenay East.
Thank you, Honourable Chair. So this information that will be collected by the homeowners grant will be then put into a general pot of information of BC residents. Is that what I'm trying to understand here?
Minister. Thank you. So right now, government collects tax information. British Columbians pay taxes here. And so there's a repository. I know, shocking, Mr. Speaker, absolutely shocking. And so there's a repository of information about taxpayers, about what they pay, and about, sort of who they are, whether or not they're married or have dependents. All that information is currently stored in a system, and that is very much recognized as sensitive information and very well protected. And the intent with this additional information through the homeowner grant is to incorporate that into that system, so that that's treated as tax information is currently treated.
Member for Kootenay East.
Thank you, Honourable Chair. Just a couple logistic questions here to finish it off. Why is there, and this is just my understanding, why is the 65 plus grant not happening this year? Streamlined through government that you're proposing with the homeowners grant?
Minister of Finance.
Can I just ask the member to clarify? I didn't quite hear what he was referring to.
Kootenay East.
Sorry, Honourable Chair. I was just, there's a 65 plus grant that's available, and apparently it's not being part of this. That will have to be paid locally. Am I understanding this correctly, or maybe I'm getting some bad information?
Minister of Finance.
Thank you. I just want to double check. I think he's referring to the seniors portion of the homeowners grant, and there's no change to that.
Kootenay East.
All right, no change, but it will be paid the same way, I'm assuming, as what the homeowners grant eligibility will be for. Okay, so the last question here, what happens to prepaid taxes? So, for example, a lot of people will pay their taxes ahead of time. Now most of these people have their taxes already paid in advance. What happens now? Is there a reconciliation with local governments to pay government? How does that work?
Minister of Finance.
Thank you. There will be no change.
Kootenay East.
Sorry, the minister might not have understood my question. So there are people that have prepaid the municipalities their allotment for homeowner, their taxes, their personal taxes. How will that affect if their homeowners grant if they overpaid their taxes?
Minister of Finance.
Thank you. Yeah. So if they've overpaid, really, then the municipality would have to either credit the account or give them a refund. That's just how it currently operates as well. So when I say there's no change to what an overpayment looks like when you have paid and then claim your grant. So it's the same process.
Kootenay East.
Okay, thank you, Chair. Last question. We've heard a lot about how fair this is going to be for BC residents. Did the government ever consider perhaps a hybrid solution, especially for the first year, where those who wish to participate online can do so, those who may not have the means or transportation or whatever it is, can do it the old-fashioned way and just go down to their local city hall?
Minister of Finance.
Thank you. So the member asked if we'd considered a hybrid, and that would make things much more complicated, actually. This is really a simple, it is a transition for sure, and having two ways to pay makes it, having two ways to claim the grant makes it much more simple. You can either go online, gov.bc.ca/homeowner grant, one word, or call, and in order to claim your grant. People can still go down to City Hall to pay their taxes. They're still able to do that. I don't want anyone to think that that wouldn't be available to them, but they don't in order to claim the homeowner grant. This will be the simplest way to go rather than doing some sort of hybrid.
Kootenay East.
Thank you, Chair. Just, I guess, to sum up, choice, I guess, means more stringent, not as flexible, I guess, especially when people have been doing this for decades, just to fit them in a box all at one time, especially with people that don't have, the means of information as readily available to them as some people do. I would choose to argue with the minister on that one, that that doesn't represent an easier platform, but I'll leave it at that, Chair, and I'll turn it over to next in line.
Thank you. Does the minister have a response before I call the vote? No. On clause 20, those in favor? Oh, you have one more? Peace River South on clause 20.
Thank you, Chair. Noting the hour, I still have a few minutes, and we aren't quite done on this clause, but I appreciate you trying to move things along. I just want to actually just on a couple of points through that last discussion that I have, and I will say this somewhat respectfully if it's possible. The minister highlights that the government has all this information already. It's in a safe data bank. I guess they could have used that to put out the COVID recovery grants since back in the winter when we suggested that. That aside, the minister, though, I just want to make sure she clarifies this for me if I understand, because I'm really surprised by the number she gave when she mentioned fraud on an audit of 3%. If my quick math in my head, she'll correct me if I'm wrong, or her staff will, that's about 33,000 homeowners. Is the minister saying there's been approximately 30, again, if my math's right, quickly doing it, Does that mean there's 33,000 people they suspect have been frauding the government through double homeowners grants? And aside from a rough audit, do they have any other analytical data that would verify that?
Minister of Finance.
Mr. Speaker, and the member's math is very good. But I also think in that number is also some people making mistakes, for example. So I think that I think we need to recognize that would be part of the audit. But the member does raise a really good question because we don't have that. We don't have good data. And so centralization will really help us understand what's going on so that, where people are making mistakes, we can correct them so that people understand what the nature of the program is. So that it's fair, because I think that's also really important to British Columbians, that it's fair, but also that we understand what's going on and how to identify fraud and make sure that we can take corrective action.
Member.
Thank you, Chair. So as the government's going to be able to do all this, does that mean they'll be able to identify people who qualify who haven't applied? Because we've talked about people who may be frauding the system. And again, we all agree that we want to make sure this is streamlined for the best for taxpayers and for the province of BC and for homeowners to not jeopardize anything going forward. But I'm curious, though, if that we can use that data, just came to me just now as we're talking. So if somebody didn't apply, or maybe if there's people in the past years who haven't applied, who did qualify, will the government be able to proactively now go after people with letters or emails or whatever information they have on them to say, you qualify and you haven't, don't forget to?
Minister of Finance.
Thank you very much, Mr. Speaker. So we need to remember that this is a voluntary program, so people do need to make an application. However, the centralization that's being proposed here creates a real opportunity to make sure that people get the full grant amount. So for example, a senior makes an application, they do it online, and it will ask for their birth year, so it will automatically give them not just a regular grant, but the seniors grant, but also if they're not eligible, but their spouse is, it'll automatically, it'll pull that up so that they get the full eligibility, whereas in the current system, they may not know that they can do that, and so they may not put the X in the right box and not take advantage of the full grant. The other thing that I think is important to note that there's certainly going to be certainly some audit functions, and we'll be able to go back 6 years. So if someone hasn't taken full advantage of the grant, there'll be an opportunity to I guess, backdate and make sure that they get the full benefit of the grant that's been entitled to them, but they didn't know that they could make the application for the full grant. So that will keep people whole in that respect.
Peace River South.
Thank you. So we've talked a lot about, I guess, a little bit of the extra workload to go along with some of the other members of the House that were speaking earlier, Saanich North and the Islands, for instance. I'm just curious then, if there's going to be all of this coming in, extra work coming in, has there been a determination then of, I know the minister said, bring it up in estimates, but obviously the bill's in front of us and there must be an opportunity and the minister must have some idea or some advice that's been given of maybe extra staff that'll need to be hired or a cost implication to the ministry and government to take this in, because as the minister herself said, rightfully so, this has been for many municipalities, most in fact, a bit of a burden. As a former UBCM executive person myself as well, the minister well knows that a lot of municipalities consider this a downloading in some ways, and so yeah, you don't get to hear the uploading very often back to government, but that can come with a cost as well. So I'm just curious what determination's been placed for that.
Minister of Finance.
I thank the member for his question. And as I had said earlier, the Ministry of Finance is able to leverage existing resources to centralize this information. We have a significantly well-experienced complement of staff who recognize that they can use their existing resources, and we can get into details around estimates if the member wants to get specific costing. But at this point, there's certainly recognition with the ease of online and encouraging all of that online application. It'll be way more efficient and easier to manage. And with noting the hour, Mr. Speaker.
Just one moment. Are you finished with? No, we're not. Okay, go ahead, Minister.
Noting the hour, Mr. Speaker, I move that the committee rise, report progress, and ask leave to sit again.
Members participating remotely, we're about to have a vote. Please have your card ready. The motion is to ask leave to sit again on Bill 6. Those in favor, please indicate so. Report progress and ask leave to sit again. Thank you. Those opposed? Carry.
Committee Chair.
Mr. Speaker, the Committee on Bill 6 reports progress and asks leave to sit again.
Members participating remotely, have your voting cards ready, please. No? What we are doing? When shall the committee sit again?
Next sitting.
Government House Leader.
Next sitting, Mr. Speaker. Next sitting, Mr. Speaker.
Thank you so much for reconfirming that. Thank you. We heard it. So ordered. Government House Leader.
Thank you, Honourable Speaker. I move the House to now adjourn.
Members participating remotely, have your voting cards ready, please. The motion is to adjourn the House. All those in favor indicate aye. Those who oppose indicate nay. Motion carried. This House stands adjourned until 1:30 tomorrow afternoon.